coming this morning, especially those of you that came at 9 o'clock and are staying through to HR Day 2. We really appreciate the commitment you're showing to work together as an association of schools and professionals, to work together to find ways to save, to find ways to collaborate, to find ways to learn more about things you can do to help your school and the mission. We are all ready to go for HR Day 2, but we're going to start. I want to start first, of course, as with Joan. I want to thank Ron Hill, who is in the back, who facilitates all of this, the folks here at the Radnor Township building that are masterful in like moving tables in the midst of people wandering in the hallways. And I also want to thank, we have two vendor sponsors for HR Day 2 today. We have Lancaster-Lebanon IU13, and we have Praesidium. And we're going to start this morning by hearing from both of them to talk a little bit about what they're offering, what might be helpful to you in your schools. And during the lunch break and after the program, there'll be plenty of time to talk with Annette and Ory about their products. So I'll start with Annette.
Good morning. My name is Annette Ruth. I'm an HR generalist with the Lancaster-Lebanon IU13 Human Resources Office. Thank you for taking some time to speak with me and hear what we have going on. So when I say Act 168, what's the general consensus when I say Act 168? Yeah. So we felt the same way. We are pretty high volume, and when this law came into regulation, it was very time consuming for us. So luckily we were blessed with a very wonderful tech team, and I have some great coders that work in our tech department, and we came up with a solution, an electronic solution. And I'm here to talk a little bit about that today and share that with you. So the process for us has been a couple years in the making. We literally took all of 2015 working on building this system. And along the way, we started having conversations with our member districts in the Lancaster-Lebanon area. And we got some feedback what they would like to see if we built an electronic system. So we spent most of 2015 into 16 building the system, went to beta test, and then we've been into market now for approximately 2 years. The benefit to us has been tremendous. What used to take hours now takes a few minutes. The electronic system is customizable. So what I mean by that is we can build the system to make it look and feel as if it's coming from your organization. Your candidates won't even know that we're kind of the engine in the background, okay? You will also have other great features that will streamline the process for your candidates. When we built the system, we pulled down demographic information from the EDNA system, from PDE, and so all the organizations that report to PDE, we pulled that information and loaded it into the database. So when candidates are searching organizations, they will be able to pull up that information. It will auto-populate in their form for you. Okay. So it's much better for your candidates. It's going to save you time and energy in your office. Some other benefits, obviously, it's a web-based product, first of all, so there's no software to buy. It's very easy to implement. We actually have a couple of your members who have already implemented the system and are using it now. The compliance part, you know, a lot of districts are always worried about compliance and making sure that they're doing their due diligence in getting those responses from employers, or at least getting attempts to those employers to respond. Our system is built so that it will track each time the system sends out a notification to that employer, so you will have a record of each attempt that the system sends out to that employer as well. Okay, so these are just a couple of features that the product has. If you are interested, I'd be happy to speak with you at some point this afternoon, or we could also schedule a personal demonstration as well, so I could talk to you a little bit about your district and how it would work for you or your organization. Just wanted to give the opportunity, Heather and Cindy from Hill School and Episcopal Academy, are they still here? There you are. So these are the two ladies that have already implemented the system. So, feel free to touch base with me, touch base with Cindy or Heather if you have any questions. But I'd be happy to answer any questions at this point. So we have a very quick turnaround time. Once you get your documents back to us, we can typically have you up and running within about 2 to 3 weeks, depending on schedule.
I just want to offer an endorsement, and suggest maybe that Rachel, maybe you can do a webinar, because I think a lot of you are going to be interested in, instead of for Annette having to do first one-on-one demos, we can do a couple of webinars. We rolled it out last month. I mean, it takes Act 168. You're no longer faxing or scanning and mailing. Whatever versions of that you do, you put a little bit of information in, you get a link, and the system emails that link to your candidate. The candidate takes it from there. I cannot even say how much this has freed us up from admin. We all want to do better things, we want to be more strategic. Getting that paperwork off of our desk is one way to do that. And fully endorse this and applaud that. She worked with the IT department at their intermediate unit to come up with a solution. And it's kind of like open source, their pricing is super fair, practically free. So, it's not great, but it's a really fair pricing model to free us up from something that's really burdensome. So I just wanted to offer a personal endorsement of this.
And I haven't ordered Annette to actually tackle some other HR initiatives, and I'll continue to. So clearances, I think she can build a program for the Act 168 and make it streamlined. Maybe their team can do it.
We have it on the list. The next product actually that we're currently working on in beta testing is a leave tracking management system. We've basically taken the bones of this system and applied it to a leave management system. I saw another. It's the Act 168 database. It's from IU13, and we have like an umbrella organization that is called HR Solutions for Schools. Yes?
Are you able to share anything on the pricing model for it?
Yeah, I can definitely. So it's a flat model pricing. It's $5 per candidate processed through the system, and there's a one-time $500 implementation or setup fee. The $5 per candidate is, it doesn't matter whether that candidate has 1 form or 15 forms, you're charged a flat $5, okay? We did that because typically from year to year, there's not a lot of change in your hiring from year to year. So from a budgeting perspective, you know, it helps you, whereas there's no way to budget for how many former employers a candidate would have had. Any other questions? Yes?
How many times is each form sent out to the candidate?
That's one of the customizable features that each organization can determine. So if you want us to set up the system so it'll do it 2 attempts, 3 attempts, we have some organizations that have upwards of 8 attempts. So it's, yep. Yes. Not yet. The link will come from our own system, so it's not something that we've built the bridge yet where you can take that link and essentially embed it into another email. It's going to be a separate email from the system. So typically what we've had districts do who do have some of that already in process, what they've done is they've changed their wording in their onboarding emails to let the candidate know that they'll be receiving a separate email to complete their Act 168s. Okay. Thank you very much.
Thanks so much, Annette. Ory from Praesidium is going to address the group next. Thanks, Ory.
Thank you all so much for coming today, and to Rachel and the PAISBOA team for putting this all on. My name is Ory. I am the Vice President of Product Services at Praesidium, and I'm sure some of you are familiar with us, but I'll give you the nickel tour here. Praesidium is a risk management firm that is dedicated to preventing the abuse of children and vulnerable adults. That's all we do. We do this through a systems model. There are a handful of things that we need to do to make sure that abuse is prevented. Things like make sure everybody gets their screening, make sure everybody gets trained appropriately, ensure that we have policies addressing behaviors, and that we are supervising and managing against those policies. So Praesidium has a team of folks based in Texas that travel really around the world working with organizations, and those organizations are absolutely often schools, independent schools in particular, as well as public school districts. But then we are at your YMCAs, your Boys and Girls Clubs, more and more medical centers, and shopping malls, cruise ships, anywhere where we've got that kids club kind of angle. We work with organizations to implement individualized solutions focused on abuse prevention. And that's something that we truly embrace. Abuse is preventable. This isn't something with a margin of error. We can accept the occasional situation because we can't win them all. We want to help our clients find that rock-solid solution that will make sure that you guys are able to focus on your mission of educating amazing students, focus on that amazing culture that you are dedicated to, and that you're not bogged down in sometimes the noise related to false allegations, but certainly the absolute trauma that goes into an incident or an alleged incident in your schools. So I'm happy to talk with any of you throughout the course of the rest of the day about different kinds of solutions. We've got the basics to help you with those compliance pieces, but as your school looks internally and tries to figure out how do we move abuse prevention into a just woven in core cultural piece, we really want to help you move into a commitment phase where this is just part of your DNA. So we've got solutions to bring you over that finish line so that every day, without even thinking about it, abuse prevention is happening within your organization. So I'm excited to hear about this topic, so I want to get us going here. All right? Thank you all so much.
Thank you so much. So they'll be available this morning and throughout the afternoon to answer questions if you have further questions. And the links to their websites were in the blast that went out on Monday, inviting you again to this event on Wednesday. So, and you can also find those links on our website. So we are delighted to have back again Michael and Susan from Fisher Phillips to continue HR Day 2, Part 2 of what we had begun in the fall. And I'm delighted to pass it on to the two of you. Thank you.
Thank you. Good morning. It's unusual for people to invite us back for a second time, so we really appreciate it. As Rachel said, I'm Michael Galey. I'm joined with Susan Guerette, and we are from Fisher & Phillips. Fisher Phillips is a national labor and employment defense firm, meaning we work with our clients in every facet of the employment relationship, from advising on compliance issues, hiring and firing, all the way through litigation. We are here this morning to talk to you, well, this morning and this afternoon, to talk to you about a number of topics, the first being social media and how that relates to your schools. Obviously, there are a number of ways that schools are using social media these days, and to a number of purposes. I went to the Mercersburg Academy, and my dad teaches there. He's actually retiring in June. And yesterday they had some fundraising drive, so my Twitter feed had like 8,000 videos of people thanking teachers throughout the years in connection with their donations. That's just one example of the myriad ways that schools are using social media today. I should have said at the beginning, and I probably don't need to say it to this group, please don't hesitate to interrupt us and ask questions as we go through the topics today. This group's always been pretty good about that, but yes. I assume so. Yes. Like I said, schools are using social media for branding, to promote their mission, to connect with alumni such as myself and ask for our money, to improve access to information. All of that is excellent, but that comes with certain challenges, as does how students are using social media. I don't know about any of you, but social media was not a thing when I was in high school. That's probably for the best. But it's obviously ubiquitous today. And students use it in both positive ways and negative ways, of course. There are very useful aspects of social media, the ability to communicate easily, the ability to access information easily. There are also negative aspects to social media. Communicating inappropriate comments among a group of friends or other people.
We tried to have a system so we wouldn't take each other's slides because we always end up doing that. So I think what we
Probably
tried.
still gonna do it.
Yeah, we're still going to do it, but we tried to break this into employee situations with social media and students. So we're going to talk about employees first, but feel free to jump in anytime. You guys are having really challenging issues. In fact, I had a head of school the other day who called me and said, "I can't believe that this is what my job is now. I thought I was going to be an educator," and he was really dealing with bullying and more situations like that, as opposed to what really he felt like his mission was. So you guys are really getting some challenging situations. So looking at employees right from the start hiring, we have a case study for you. Your school needs to find a new school librarian. You post for the position and receive a bunch of resumes. As you go through them, you put their names into Google and you end up viewing their posts on Facebook and other social media. You interview a number of them and you end up hiring someone. A week later, one of the applicants contacts you and asks why you didn't choose her. You explain she was not the most qualified, but she seems skeptical of your answer. You hear through the grapevine that she believes she was not hired because she was 3 months pregnant. Are there any concerns about this? Great. Any thoughts? You want to share any thoughts on this? Yes, exactly. So, the concern here. Right, and we're seeing a lot more of this where applicants are coming back to the school saying, "Hey, why didn't you hire me? What didn't I have? Where was I? What could I do differently?" Are you guys seeing that in your hiring? Yeah, so applicants are really, a little bit more in your face these days, and they're not just letting it go and taking your sample, your form letter, and going on their way. They're really pushing for information. So yes. Well, this would be a good question for everyone else too, but what I'm hearing is more like the 25 to 35 group seems to be pushing back. Is anybody having a similar experience or a different experience? Over 40, okay, interesting. Yeah. Uh-huh. Right. Right, exactly. So yeah, so it's, yes.
Outside of HR's knowledge,
Mm-hmm.
they may be using
Yes, and that's up. Right. Right. And that is hard, and I know that's a struggle for you guys. We come in and tell you all this great stuff that you should be doing, but you don't always have control over whether everyone at your school is going to do it or not. So these are tips we're going to give you, but you're right, it's hard to implement it. So you hit the nail on the head. The concern there is that, if when you did those internet searches, say on Facebook, she had put, "Hey, great news, I just found out that I'm pregnant," or there was some kind of shower for her, or something that gave you that information, she could then say that that's the reason you didn't hire her, because you knew that she was pregnant, and so you discriminated against her. So what we try to do is encourage you to have a process. And the process that seems to work best is to have one person. So first you want to, and we've talked about hiring in the past, you want to have a team who's going to be in charge of hiring, or at least one person who's going to be the ultimate decision maker. And that person should not be doing the internet searches. So what you want to do is have someone else do the internet searches, and maybe talk to that person in advance and say, hey, these are the kinds of things I'd be interested in. If you saw this on social media, I'd be concerned about it. But then have them do the internet searches and come back to you only with the information that's pertinent to the job. So they're not going to tell you that the person, the race of the person, or that they're pregnant, or that they have a disability. They're just going to tell you the stuff that's pertinent to the job. And that really does protect you to some degree, because if you didn't know about it, then you couldn't have discriminated against the person. So if you didn't know they were pregnant, you couldn't discriminate by not hiring on that basis.
And that's one of the best defenses in the context of an employment discrimination claim is we had no idea that you were X.
Right. Yes.
So in that case, the person, who does the internet search, then shares with someone else who truly does not know the specifics. So they are being genuine, they don't know.
Right.
But that the accuser, continues to suspect, did really do know, didn't do know. So how, what sort of one way against the other, how can that person really, how can that person really show that they actually did not know? They didn't know what really did.
Yeah, well, first I will tell you that when we do counsel schools about pushback from the applicants, you really don't have to get into a lot of back and forth with applicants. So we would really discourage you from doing a lot of that. I mean, we really have, you probably have a form letter that you send out saying, thanks for your application, we've gone in a different direction. We really, encourage you to stick with that. If you have someone that you really feel like you need to explain because they're part of your community, we can counsel you on what to talk about. But you really don't have an obligation to go through, tit for tat why you didn't hire that person. And we'd really discourage you from doing that.
I was just going to say, from a litigation context, if let's say that the person from the hypothetical filed a pregnancy discrimination claim, you're absolutely right. She would be saying, you did this because I'm pregnant, and we would be saying, we had no idea. The good news is we would have other information that we could rely on to support our side of the case. We've implemented a policy whereby the people that are making the hiring decision don't review this. Oh yeah, absolutely. We've communicated that to the employees. Here's an email showing the distribution of that policy. We'll have testimony from the people involved, you know what I mean? So on the one hand, you're right that they could file that claim and make the argument, but we'll have, documentation and testimony to support our side, and the other side will have, yeah, but I'm sure you looked at it, right? And that's just a much stronger case than had you actually looked at it, and then we would have to explain, well, this is why we made the decision for this person over that, even though we knew you were pregnant.
For protected right, you have to have a social media. I mean, that's your decision to have social media. Why does that, you don't have to do social media. You don't have to pick up. I mean, if you're gonna engage in that and be in that realm, why are you not just subject to the rest of what happens and make figure out stuff about it? I mean, I've done that. I've served people on Twitter and Facebook. They're locked down. Like, you can't get to them.
Yeah.
So, like,
Yeah.
At this point, if your page isn't private, that should be a red flag anyway.
Yeah.
Right?
Exactly, right? You'd be like, hey, I can access everything about you just by looking at you, but.
Yeah.
So to your point, there's nothing inherently wrong with looking at the information. And let's say you went on the Facebook page and, the person has a picture of her and her friend smoking a bong, right? Like, okay, that's a red flag that A, you're doing that, B, you're posting it on social media, and C, you're doing that in a public context, right? It would be entirely appropriate to, in Pennsylvania at least, to consider that. The problem is, you may find out information that is not appropriate to consider. Age, gender, sexual orientation, religion, all of those protected categories are things that you don't need information regarding to decide whether or not the person is appropriate. And that's the balancing test that internally at your institution you need to go through. Is the risk of finding out information that is protected greater than the risk of knowing the information that may be useful, the pictures of them using drugs? Or is the picture of that does that outweigh the risk of finding out something that may be held against you later?
And does that make sense? Because we're not saying don't do internet searches. They can actually be useful. Yeah.
You're going to get back, that somebody's going to sue you because you found out on social media posts. When that is all voluntarily put out there.
Right.
You voluntarily put all that information out there, and it's on the internet, and but you don't have to go on Facebook, you don't have to go on Twitter, you don't have to go on Instagram. Nobody's going to run to your head and say you have to be out there. So if you don't put that information out there, what should you want to do? That's the risk you took. That, hey, you're going to find it out. You don't want it out there, put it out there.
Yeah, that's the risk you take with non-protected information. But
Yes.
I'll tell you a story that's not social media related. I had a client once who fired a woman after 4 days. And when we got on the phone, I said, well, why did you fire her? And he said, well, for performance. I said, performance? She worked for you for 4 days. He said, well, in all honesty, when I felt like I was duped. And I said, well, what do you mean? He said, well, when she came in for her interview, she wasn't wearing one of those things on her head. But when she came to work for me, she was wearing it, and I feel like she tricked me. Okay, we're gonna settle this case, like right now. That's the problem, right? If someone in that context goes on the social media page and says, oh, well, this person's wearing a hijab, we can't possibly hire them, you're gonna lose that case, and you're going to lose it very badly, which is the message I had to send to that client, right? That's the concern. It's not the things that are okay to consider. It's that you'll have somebody consider something that's not okay to consider. And then at that point, if that guy got in front of a jury or at his deposition and said, yes, I fired her because I felt like I was duped because she wasn't wearing that thing on her head at her interview, we're going to lose summary judgment as the employer. Before we even get to trial, we're going to lose that case. And we're going to lose it big. That's the concern, is that nobody in this room is going to utilize that information, right? We've talked about that kind of stuff enough during these presentations that we all know better, but not everybody does, sadly, and that is really the concern.
Okay, so another thing that's coming up is sometimes we've had, and luckily not too much of this, but you can't ask people for their passwords to their social media. You can't ask people to access that. There are actually specific laws on that, and those laws are really developing. I think we're going to see them all over. So don't do that. If it's protected, it's protected, and you can't get to it, and you don't have the right to ask for it.
So now let's talk about, we've gone through the hiring process. Nothing that we've seen on social media, if we looked at it, has prevented the hire. And we have Howard, a current language teacher at an independent school, writes a pornographic statement about another teacher on the school's social media page. Can the school become liable for such statements? What do you guys think? Well, I'll tell you what, even if it wasn't done at school, the school can become liable. We're going to talk about harassment and hostile work environment a little bit later, but that's exactly the concern in this context, is that you would have an employee with a hostile work environment, a harassment claim based on that posting. You could also see potential claims for negligent hiring, negligent supervision. So obviously, the school has an interest in continuing to make sure that employees aren't saying or doing inappropriate things in their social media. That's not to suggest that you should set a calendar reminder every month to Google all of your employees and see what they're posting on social media. More likely, you'll get a report from somebody that, hey, we saw so-and-so posted this, and this is a problem. Like I said earlier, even if it's not something on a school-related website, or if it's not during work hours, we still have an obligation to that employee. Now, we can't consider everything or hold everything an employee says against them. There are certain protections for employees, even if those postings are unfavorable, that we're going to talk about. For instance, if somebody pointed out a safety infraction, what would be a potential OSHA violation, we can't say, oh, no, you're fired. You can't say that stuff on social media. No, that's a protected statement. Now, if we're using employee sites, if we're using employer sites, obviously we have a little more control over that. In that context, we want to make sure that it's clearly not an open forum, that we make it clear that the posts on that particular page, let's say it's the alumni page that I referenced earlier, are for the purpose of that page. You can require advance permission to post on school-related social media sites, and obviously apply all of those standards consistently. To your point, people have the right to either post on social media or not post on social media. And we have the right to hold them accountable for those postings in certain contexts. We have confidential student information. Obviously, if you were posting like, little Johnny got a B on his math test, he's such a jerk, that's a problem, right? That's not a protected communication. We also have concerns with harassment that I discussed earlier. However,
and before I get to this, actually, how many of you have like a school website that people can post on? Is that something you're doing these days? Like, no. Okay. I'm actually hearing about more schools doing that.
Like a website, one thing, but like what about participation in Instagram and you have school Facebook?
Right, like a Facebook page, right. How many of you guys have a Facebook page for the school? Right. So you do want to start kind of being attuned to that, and I'm seeing more and more of that. In fact, I've had 2 schools recently who called me because parents are becoming really savvy, and so there'd be like a 5th grade XYZ Academy parents page, and all the 5th grade parents would be on that. And I had 2 schools recently who said, we're trying to pull that in to our school Facebook page so that they're less likely to go on that, because it was really getting out of hand. I mean, they're really posting inappropriate things about kids and other parents on there, so they were trying to discourage it. And so they were kind of pulling it more into the school Facebook page, which is fine, but then you do have to make sure you have those pointers that Michael talked about so you can take down posts, so you can limit content, so you can really, make sure you're managing that so you're not then liable for something that's posted on it. So this is unfortunately going to be something we're dealing with more and more as these social media forums become more important and more popular. And I will tell you, we're going to talk about policies at the end, but you do want to make sure that you put in your enrollment contracts and your student family handbooks that you can adjust their enrollment based on what parents are doing off-site. Because we've also had a lot of situations recently where parents have been fomenting problems in the community and the schools have wanted to unenroll the students. And so that's something we're seeing more of as well. So make sure when you're thinking about your policies, you give yourself the ability to unenroll students if you have parents out there, because social media can be devastating now to schools where you have parents out there bad-mouthing the school and you want to be able to take action if it's happening. Now, you do have to balance that because obviously you're in the business of enrolling kids, you don't want to be kicking them out. But at the same time, we are seeing a lot of problems with this area. So now getting back to this topic, so you can discipline employees for certain things, but you actually have restrictions. And this is one of the hardest things for schools to understand is that the law says that employees have the right to, kind of try to unionize, try to gather and talk about their jobs. And so the NLRB has said that you can't restrict employees from doing certain things, from certain protected speech. Employees have the right to say things that go towards whether they are going to talk about their work and the status of their work. So Section 7 of the NLRA, that's a National Labor Relations Act, protects employees who engage in concerted activity for their mutual aid and protection. And Section 8A of that also prohibits an employer from interfering with or restraining them from engaging in that conduct. And we're going to talk about that because it's going to seem a little crazy to you, but it's actually the law, and they're enforcing it more and more. So this is a great example, and one that happened at a school a number of years ago, so it will kind of be more relatable. We had a school, and the theater teacher there was, first of all, let me ask, how many people have heard of this case already, the Dalton school case? Okay. So we had a theater teacher, worked on a play, put a lot of time and effort into it, and then there was a lot of commotion in the community about the play. They decided to change it. The administration stepped in and decided to do something different. The theater teacher and other faculty members were really upset about it. This particular teacher shared email exchanges with other department colleagues, really criticizing the school, being pretty adamant about how he thought the school was handled it improperly, was ineffective. One email suggested the school administrators should apologize for not being honest, forthright, upstanding, moral, considerate, much less intelligent or wise. So he didn't pull any punches. He was pretty critical. And that employee was reported, that email was reported to an administrator. And the school terminated the teacher who sent it. But the administrative law judge found that the emails constituted concerted protected activity. So we really have to be careful, because sometimes I'll have, a lot more, often it's heads, but who'll call and say, hey, this teacher is really bad-mouthing the school. He or she is going around talking about how we should have given bigger raises this year. I'm really sick of it. I want it to stop. And that's exactly the type of protected language that you have to let happen, actually. Ooh, sorry.
As is often the case in the law, there is no bright line rule that I can tell you, well, this is and this isn't protected concerted activity. Protected concerted activity, which is what the NLRA protects, includes 2 or more employees acting together, or one employee acting on behalf of other employees, regarding the wages, hours, or other terms or conditions of employment. So wages, that's pretty easy, right? Hours, that's pretty easy. What does it mean, or other terms or conditions of employment? That can include anything with respect to commentary about supervisors, commentary with respect to vacation policies. Anything that relates to their employment with the school can constitute protected concerted activity. Although it generally requires 2 or more people acting together, so you get together and you say, hey, we're really pissed off at the way that the school is treating us. It doesn't necessarily require that. In the email instance where the gentleman was sending the email, even though he was only one person sending an email, he was clearly doing it on behalf or in relation to a number of other employees, right? In either context, if it's 2 employees approaching administration, 2 employees talking amongst each other, 2 employees talking outside of school, any of those conversations could potentially constitute protected concerted activity if they're related to the terms or conditions of employment. The analysis also looks at whether or not, if they're seeking an improvement to policies or procedures, does that improvement benefit more than one employee? So, if John comes up to you and says, hey, I'm really mad with the way that you pay me, that's not necessarily protected concerted activity, right? He's not engaged on behavior that could improve the conditions of more than himself. That in of itself is not necessarily protected. If John comes to you and says, I'm really ticked off at the way you pay us, that's a very different statement. Here are some examples of activity that the NLRB, which is the National Labor Relations Board, they enforce the National Labor Relations Act, has listed as examples of protected concerted activity. Employers talking about improving pay, work-related issues beyond pay, such as safety concerns, or an employee speaking to an employer on behalf of 1 or more coworkers about improving conditions. One classic mistake that companies make is to tell employees that they can't talk about what they're paid. We see this all the time. Don't tell anybody what your salary is. Don't tell anybody what you get paid. That is actually a violation of the NLRA, to tell non-managerial employees that they can't talk about their rate of pay. And we do see lawsuits on that. That's a very easy and classic example of how you can run afoul of the NLRA. Next time I'm going to get a bunch of these buttons printed out and I'm going to start selling them. But this is to illustrate the fact that wearing a button such as this could be considered protected concerted activity. Any union-related activity. I don't suspect that many of you here have unions on campus. But obviously, teachers' unions are relatively common across the state in the public school arena. If there was any discussion about expanding that to your school, that's protected concerted activity. You cannot discipline an employee for discussing union-related activity. You can't discipline them for wearing a badge saying, join local teachers 68. Even statements that appear to attack supervisors can be protected concerted activity. You know, if you have employees talking about how awful so-and-so is, because he is always yelling at us, you know, and or so-and-so is so awful because she never lets me come in even 5 minutes late, even if I have a good excuse. You know, even if you're complaining about a supervisor in that context, that can be protected activity. That's kind of hard to wrap your mind around, the fact that you could have two employees bad-mouthing their supervisor and not be able to do anything about it. And that also includes statements through social media. Again, that's another area where it's really hard to wrap your head around the fact that you could have a Facebook page, you know, that is the teachers of XYZ school start their own Facebook page, and they get on there and, you know, they just really can't stand Bob. He's just such a jerk. You know, the head of school, Bob, is just such a jerk, and we can't believe he does A, B, and C. All of that could be protected concerted activity, and we wouldn't or shouldn't do anything punitive in that context. Again, just a couple more examples of things that have been considered protected concerted activity: handing out leaflets, and obviously talking about policies. Yes?
Can you say to an employee that that's inappropriate?
No.
You can't say anything.
No, unless there are certain things that you can't say. You can't make defamatory comments. You know, so no, they can't make defamatory comments. Employees, you know, if the employee said, to use my Bob example, you know, and I also heard that Bob murdered a guy, right? And that's clearly not true. That's a different story. That's not protected concerted activity. That's defamatory, and we could address that. We can address comments that are harassing or, you know, would otherwise be against the law. So if we have a discussion about, if somebody went on social media and said, you know, all these old teachers really need to get out of here, you know, although that could potentially tangentially be related to the terms and conditions of their employment, that's also against the law under the ADEA. You know, so you could address behavior in certain contexts. It's just very limited in what context you could address that behavior. Even if they're complaining about a teacher or a supervisor, if it relates in some way to the terms and conditions, you know, if it is so-and-so is a jerk because he is always holding my feet to the fire for XYZ, you know, that actually sounds like protected concerted activity that we couldn't discipline for.
Yeah, we'd want to talk to you about what they're saying. I mean, you know, if they're just complaining about, you know, Nancy keeps taking my chair, I mean, like, that might not be something that's, you know, the conditions of employment. We might be able to work on what they're saying. But if it's like, geez, they're not giving us enough vacation time, or it's not right that we don't get, you know, to come in at 7:20 when schooling starts at 7, you know, like, if it's something more conditions of employment.
Yeah, it can even be the difference between Nancy keeps taking my chair and why don't we all have chairs as nice as Nancy's? Those are two somewhat related statements, right? But the second one is clearly something that relates to the terms and conditions of employment, where the first one may not be. Does that make sense?
The other thing too is that this comes up more often when we're going to take action against the employee. So, you know, this is the kind of thing we wouldn't want to fire over. So as a school, you might say, look, it's worth saying something to Nancy because she's really disrupting the community, you know, even though maybe, you know, legally it's on the line. But when we get into firing over this is where you could be totally wrong. And so we want you to be careful taking action against the employee.
Yeah, that's an excellent point. You know, in order to run afoul of the law, you need to take some sort of adverse employment action on this. Simply going to the employee and saying, like, hey, this is not the most productive way to have a discussion with your colleagues. It may be a little better. Let's talk about this. Let's talk about way. You know, there's nothing wrong with that. But saying, hey, here's your first written warning for this behavior. Don't let it happen again, may be problematic because you've taken an adverse employment action potentially.
And let me also point out too, it's different if, you know, your employee Nancy goes to her co-employee and talks about this stuff. If a parent walks in and she's like, you wouldn't believe what they're doing this time, well, that's not concerted activity to improve her job. That's just bad-mouthing you to your community. So that I think I would feel pretty comfortable saying that's not trying to get employees gathered to change their circumstances of employment.
Yeah, there are two pieces, right? It's the the subject matter of the discussion has to relate to the terms and conditions, and it also has to be designed to improve those for the employees. If you're just posting on your Facebook page, boy, do I hate so-and-so, and it has no actual connection to the school in any way, that's probably not concerted activity. Here we had a school district that was sued for reassigning an employee's duties after they discovered blog postings that she had made about the qualifications of newly hired employees. They thought the blog breached privacy expectations and professional standards. The court found the blog to be racist, sexist, vulgar, a breach of confidentiality, and as such, did not address any matters of public concern. That matters of public concern is a term of art relevant in the First Amendment context. Is anyone here a public entity? Okay, the analysis is slightly different when public entities are covered by the First Amendment. Those of us in the room are not. So, you often hear, well, I have a right to say whatever I want under the First Amendment. No, you don't. Not in our school. If you went and worked in a public school setting, you would. The First Amendment only applies to government action, not private action. I think the same would be true in a private school here. If you're making racist comments, sexist, vulgar comments, those are not going to be protected under any statute.
Okay, and I think Michael really covered this earlier, but this doesn't just apply to our unionized schools. This applies to everybody. So this is going to cover you even if you're not a school with a union. Okay, so are there limits to this protection? Yes, there are, but really be careful about saying, oh, this is an exception. If the concerted activity, the comments are reckless or malicious, if they're sabotaging equipment, threatening violence, spreading lies, revealing trade secrets, those are all bases to say, okay, you have to stop. But you can see the court really makes you put up with a lot. So when does an employee have a claim? And again, it's hard for an employee to make a claim because the activity has to be found to be concerted, as Michael talked about. You have to, as the employer, have known about the concerted nature of the activity. What was the employee trying to do? The activity has to be protected by the act, and there has to be an adverse employment action. So again, if you don't fire the person, if you don't take away their benefits, change their vacation, you're not going to give them a claim against you.
And I just want to jump in. It's important to keep in mind, too, that, we talked about you can go to the employee and say, hey, this may not be the most productive way to approach this. Let's talk about, a better way to have this discussion. And that's not an adverse employment action. But be very careful that if down the road something else happens and you say, all right, we're terminating you for X, and in the termination letter you write, we've had to talk to you already about how you've had these discussions, and then you went and did this other thing, now you're fired. Well, you brought what was not an adverse employment action into the context of the adverse employment action, and that employee could say, well, wait a minute. If you hadn't considered my protected conduct, you wouldn't have terminated me. Therefore, this is a violation of the act. So if you're going to have those, one-on-one conversations about discussions in this arena, make sure that you don't, in the future, rely on that in some sort of disciplinary context. That needs to be separate and apart from any future discipline.
Okay, so a hypothetical. Laura, a teacher at an independent school, posts the following on her social media site. I feel the administration's decision to give everyone a $500 raise next year but expand their working hours by 4 hours per week is unfair. Fellow teachers, what do you think? I invite you to respond to me. Let's get some dialogue going, my friend. Any thoughts on, can the school discipline for this? No. Okay, yeah, this is squarely within on all counts. It's trying to get her colleagues to talk about it, and it's clearly within a protected activity. An independent school creates a policy prohibiting the school staff from posting in any media photographs of the staff members wearing hats or shirts with the school logo or riding in a car with the school logo painted on it. Could this policy violate the National Labor Relations Act? Yeah, so this is a tough one, but I don't know if you remember going back to Michael's slides, they can wear pins, buttons, so the buttons can say, Fisher and Phillips stinks on it. You know, if it's part of the concerted activity, you know, now I can't just wear it on the weekend because I'm, you know, having a bad day, but if I'm talking about that in the context of something where I'm trying to improve my wages or my conditions of employment, courts have actually said that's okay. So we do have to be careful. Sometimes I see handbooks, when we go over handbooks and they have things in there, we want to take those out because that would be a violation. Want to add anything to that, or?
No, I think it's important to keep in mind that you can forbid an employee from, and I may be stepping on someone's later slide, but you can forbid an employee from purporting to be communicating on behalf of the school, although that's different than Susan's hypothetical. You can say, hey, you can't go online and say, on behalf of Westtown School, I would like to let everyone know that our teachers are terrible. That would be problematic, and you could say you're not allowed to take action on behalf of Westtown School. But you can't say, Michael thinks these teachers are terrible. That's allowable. So there is that distinction as well. A non-union teacher upset that her supervisor reprimanded her in front of another supervisor updates her Facebook page with a photograph of her supervisor with a curse word under the photo. Does anybody think that that would potentially be protected activity? I think probably not, although I did sort of go through some mental analysis of whether it mattered what the curse word was. Right? Like if you wrote asshole, you are conveying a certain message with that word that may be different than other curse words, you know, but I still think that doesn't actually convey a sufficient amount of information to be considered protected activity. So no, I mean, simply posting the photo and writing any curse word under it would not be protected concerted activity. However, what if you wrote, my supervisor is unfair, don't you agree? And then many of the teacher's coworkers online express support for the teacher, add criticism of the other teacher, and threaten to bring action against the school. Does that sound like protected concerted activity? Yeah, agreed. Yeah, so there's always like a sliding scale of appropriateness from don't do it to, you know, we recommend you tell everybody what you make, right? You know, as you slide down that scale, it becomes more and more appropriate. Certainly for non-managerial employees. So for managerial employees, that would probably include department heads, you know, anyone in this room most likely. You can tell them that they're not allowed to discuss those things. For non-managerial employees, you cannot say, don't tell anybody what you make. Now, can you get away with, you know, we think it's best if you keep this information to yourself? We'd be arguing about that, right? You could imagine us being in front of the National Labor Relations Board saying, no, we never told her she couldn't do it. We just told her that it wasn't the best idea. And the other side's going to say, come on. You know, so you can imagine how, as you de-escalate the message, it becomes more appropriate in that context. I think then it becomes a matter of really what are you willing to, what's the line that you're willing to toe? Is it, you know, we'd prefer you don't do this, it's not the best idea to do this, you know, or is it something even a little more gentler like, you know, we don't tell anybody else what your salary is. Wink. Right? Nor should you, is the implied message. But that is a much more defensible statement than we don't want you to do this, which is more defensible than you can't do this. Yes, ma'am. Then there would be no need to tell them not to discuss it. Yeah, I mean, you're really asking for it if you do that. For a number of both not terribly concerning reasons and terribly concerning reasons. So, like, if you published a list and all of your female teachers were being paid 95% of what your male teachers were being paid, you know, we'd be having a very long talk about how to make that right before litigation. Or conversely, you know, all of your older teachers were making less money than your younger teachers. You know, that type of information would be solid gold to a plaintiff's attorney. But let's say every single teacher makes all the same, you know, the same amount. Well, there's nothing inherently wrong with publishing that, but yeah, that's the argument we ultimately would have to get into. But I can almost say with certainty that if a plaintiff's attorney got a hold of a list of salaries and they could draw lines between, you know, certain categories of people making less than others, we're going to see the lawsuit. There may be very legitimate justifications for that that would ultimately allow us to be successful. You know, well, this person has a master's degree and this person has a BA. Okay, that's an entirely appropriate reason to pay people differently, but we're going to have to explain that to the court at some point.
Same but different. The salary is personal, and we recommend that you don't talk about that. We're not an investigation. Can you conclude the investigation or begin the investigation by saying, this is not going to be talking about outside this room until parties have been interviewed until we conclude?
No, I mean, you can't, as a matter of, you know, directive, say you can't discuss this with anybody. Again, that's a situation where we're conducting our investigation into the issue. Let's assume it's somebody's complained that they've been harassed, and we're going to conduct an investigation. You know, it's entirely appropriate to say to the person, you know, we're going to do our best to keep this confidential. We're going to look into these issues. You know, we hope that you give us the opportunity to do that, and then we'll get back to you. But you can't tell them that they can't go talk about that. You know, to go to your coworker and say, you know, Bill's harassing me, would almost certainly be protected concerted activity. You know, Bill's harassing me. What should we do about this? Unquestionably protected, I think. You know, so that's a message of, look, we're going to look into this, you know, we hope you give us the opportunity to do that, but to simply say you can't talk to anybody about this would almost be a per se violation, I think, of the NLRA.
So, the supervisor now they get blasted on social media. They're not in the case now that's harassment on the side.
It depends on,
Friend Central School, Monica says, Rudy Faber works at Friend Central School, he's the worst, isn't he?
here's what I'd like to ask. We have a whole harassment slide deck prepared. Let's talk about that question when we get there. Because what is harassment under the law is a very technical analysis. So let's talk about that, and then we'll go back to the question of, does that person have a harassment claim?
Well, how about right to privacy?
Don't let me forget.
How about right to privacy? I mean, that picture's getting taken at work. I mean, I'm not in a public space. You're not right to privacy. We're talking about my workforce. Like, I would, you should just be snapping pictures of me all over the place and then posting on social media.
Yeah, so there are a lot of different ways that we could look at that issue. The first is we'd have to figure out where the picture came from. It's likely you could just go online, Google someone's name, and, you know, copy that picture and throw it on there. You know, if I broke into your house and stole a picture from your mantle, obviously there would be other concerns. Now, just because if she did that, we could certainly take action against her for breaking into the guy's house, right? But not for posting the picture and talking about it. You know, we wouldn't bring that message into it. Pictures in the workspace are a whole different animal as to whether or not that is truly a public space. You know, if I walk onto your campus, I would have no expectation of privacy in that context. Now, if you walk into my house or if I walk into your house, maybe the analysis is different.
I will say, too, that I think it's really going to depend on exactly what's said. So if she just says, hey, you're a jerk, and I don't like this guy, that's going to be a lot different than I don't like this guy because I'm late because I'm dropping my kid off and he keeps giving me, you know, like, if it's really, there's a but and it goes to the conditions of employment, that's where it's going to be more protected. If she's just, you know, name-calling and saying you're a jerk, that is probably going to fit into that, which Michael will talk about later. Oh, you have a question over there, Michael?
Oh, yes.
No, I'm just wondering, if you had to discharge a person, you want to make sure that since it's an employee matter, you want to keep it as private as possible. Can you say to your faculty, you know, since this is a confidential matter, if anybody asks questions, just have them talk to me? Is that the safest way to do it?
Well, that can actually be a very somewhat complicated analysis for a number of reasons. First of all, I wouldn't expect your faculty writ large to know all of the details of the termination.
But we don't want them to spread rumors either.
Yeah, again, that would go to the message that's being spread. Again, we talked about how there are certain messages that are clearly inappropriate. You can't talk about this. In that context, I think would be clearly inappropriate. We prefer you to keep this as an internal matter, or we prefer you to respect the privacy of this person. That's a more appropriate comment to make. But I would say, do not stand up in front of your faculty and say, don't talk about this. They certainly have a right to talk about it to the extent that they can demonstrate that discussion is protected concerted activity, right? A discussion on behalf of a group of teachers about terms and conditions of employment, right? So if the person was terminated for performance and everybody's like, oh my goodness, this person was a great teacher. How is their performance bad? What are the expectations? What's going on here? That's all sounds like protected concerted activity, right? So I'd be very, very leery of having a blanket instruction not to talk about something like that. Now we have Paul, a second grade teacher, who writes, our children and teachers and staff are 4 times more likely to have pneumonia than other similar schools because there is mold coming down from the old ceilings. My fellow teachers and students and parents, please join in with me to take a stand against these school-related diseases. Do you think there are issues with disciplining Paul for this? All right. Good. Seeing all yeses, we'll move on. I'm not sure if you next.
Oh, I think it's me. Let's see. Okay, so now we're going to talk a little bit about social media and your supervisors. Yes.
Can I ask just one
Of course.
question before we move on? There are many schools that have a group of faculty and staff that acts as like sometimes called a hedge advisory committee or something like that. So that is oftentimes a venue for faculty and staff to express concerns about wages, benefits, but also other kind of non-employment related issues. I saw recently some kind of posting suggesting that you have to be very careful with how you structure those sorts of committees. Can you speak to that? Are there sort of risks to having a committee of that sort? Or does it strike you as
I mean, we talked earlier about how managerial level employees are treated differently under the law. So if you have a group of all managerial level employees, let's say in the context of a termination decision, to go back to the prior discussion, if you're sitting in a room full of the department heads or the head of school and other people that were involved in the decision who are at supervisory level, that's totally different. They can be instructed not to talk about that as managerial employees. I think if you have structured a group that includes people across the board, I don't see how you could tell those non-managerial employees not to talk about something.
No, you're not. You're actually encouraging people to, through the mechanism of that committee, share concerns about benefits and pay. I just heard that you have to be careful how you structure
Like an
those.
employer-sponsored.
For example, if you have a strong management presence in that meeting, is that a risk to you? Because you are now in some manner controlling or trying to control the conversations that employees are having about employment conditions. If you haven't heard anything on that.
Yeah, I don't see any risks
yeah.
to it. I think you're kind of opening yourself up that if the employee who's sitting there talks to you about an issue and management doesn't do something about it, and they go back out to everyone else and say, geez, I talked to them about how our school day is starting too early and they're not going to change it. Like, you then can't stop that later conversation.
Well,
So you're kind of, opening yourself up to that.
Yeah,
but-
or along those same lines, if somebody comes in and says, well, this hasn't happened to me, but I heard from Sally that so-and-so was making inappropriate jokes. You then, as managerial level employees, would have an obligation to pursue that. And by pursue that, I mean to investigate that and say, oh, well, this has come to me. We cannot keep that confidential.
Yeah.
That needs to, so if the issue is with respect to like having a confidential forum for discussion,
Yeah,
that
there's no
can't be-
such thing.
Yeah, that
Yeah.
can't be guaranteed in that context.
So does that make sense, everyone? Because that's actually a good point. We have a slide later that says sometimes you don't want to know too much. Because if you have something like that and someone says, oh, so-and-so has been making racist comments, like you've got to now investigate that. Like you can't just say, oh, yeah, that's not good.
Yeah,
You
we
know, so
can't-
like you're kind of really,
And
which
we
is not
can't
a bad
say,
thing.
oh, this group was
Yeah.
designed to be a confidential way to express concerns, so we didn't do anything about it.
Has
Is
anybody
that-
had one of those and had experience? Yes, Cindy?
We do, we call it the faculty and executive committee. And it's a forum for faculty and staff to anonymously mention things that are on their mind. So whether it's about their colleague, or it's about their benefits, or whatever it's about, whether it's speak up in the parking lot. You name it, they'll bring it to everyone's attention. And then what we do is we parcel out who responds to the question. But there's always a response to the question. So I think what this gentleman is saying is, by us kind of tailoring the communication, are we in any way putting our schools in jeopardy of saying they don't have the right to use the press up, or there's no real formal follow-up, it's not a, these are the minutes, this is the open agenda items, these are the previous agenda items that we need to, does that make any sense?
Yeah, I don't see a,
These representatives in these committees are elected.
okay.
They're like representing the employees. These
Right.
committees of non-management folks, they're then making recommendations to management. And that's where an employer-sponsored program, and we could get in trouble. Now, my attorney told me not to worry about it.
Yeah, I honestly don't see,
It's so common in academia.
right.
That it's not, there's no case law that said that schools are not controlling this.
So in lieu of a union, this is what I would, it's a mini union.
Right. I mean, as long as you're not doing anything to discourage other communications, I don't see a problem with it. I mean, I feel like you're providing one. Now, I'd be careful what your policy says around that, and don't make it seem like this is the only place to go to talk about these issues, but I think you're just giving them another option. I don't see a problem with it, but.
Yeah, I've never seen a case where somebody was held accountable for implying that you can't say something in that type of context, where the implication purely comes from there being a forum that's specific to a certain topic. You know, that to me would be a really tough case to bring to say, well, because they said we can discuss benefits in this forum, they inherently told us we can't discuss other stuff. Well, no, that's not, that sort of logically doesn't flow. So I wouldn't have
Well, it's kind of the opposite, not that we're telling them we can't discuss other things, it's now that we're negotiating with a small group of people, that we just had benefits meeting, benefits were gonna go up 9%, now we think they're only gonna go up 2%, and we're gonna go back to the cross, and we negotiate with a small group, and then they help us in communication, with their peers.
Yeah, I mean, keep in mind that what we're talking about with respect to concerted activity is not forbidding people from communicating, which is certainly not the case there, and not disciplining them for communicating in the context of protected concerted activity. So I think as long as you're not doing those two things, you're okay as far as the NLRA is concerned. Keep in mind that if you hear concerns in those groups that relate to other issues in the employment context, harassment, discrimination, et cetera, that you will have an obligation to handle those outside of the group, right? You'll have an obligation to investigate that as you would if the complaint came through normal channels. So again, you would have to make sure that information got filtered up to the right people. But I can't see a problem with having a group that was designed in that way.
I would just make sure that nothing in your paperwork or says anything to deter someone or makes it seem like this is the or this is the word, like you just want to make it seem like, hey, this is one source of information. But yeah, I think you'd be fine. Okay.
Would that be listening for how you end up serving on that committee play a role in it? So if you have the committee and the head has picked the people that sit on the committee versus having people elected to the committee, does that play a role?
No, I don't think that changes the analysis in any way, because what we're talking about is in the NLRA context, not forbidding communication and not disciplining for it. In the other context, it's making sure that if you have a managerial employee that gets information suggesting something inappropriate has happened, that person knows to filter that up and we act on that appropriately. So I don't see how the group is composed being a problem. It's to Susan's point, making sure that the communication to the group is clear and doesn't imply that they can't talk about other things or that this is the only group that can talk about this subject.
So we're kind of switching gears, but feel free to bring us back to this topic if you have more questions. So we tried to think of different ways social media are impacting schools, and one issue is that we're finding that supervisors and managers are really being targeted for their own personal social media. So they just need to be aware that things that they post can be used against them in a litigation. So, for example, in this case, the manager wrote on his own personal social media, "What's wrong with women these days? Chicks seem to have more issues these days than Jet Magazine and keep up more drama than daytime TV and Jerry Springer combined." And the plaintiff in that case then used those comments on social media to prove a discriminatory animus, that he was a discriminatory person, had those thoughts. And I think I mentioned that at our last HR Day 1 that we had a case at our firm where a manager they used a picture of a Confederate flag that was on his Facebook page of his son's dorm room to show that he was a racist. And part of the case came down to, it actually ended up being his roommate's or his son's roommate's flag, and he was actually African-American. It was really bizarre, but that was something we actually had to deal with in the case because social media is something that, and honestly, like once you get to a jury, they love that stuff. Like it's, so just make sure your managers know that they really want to protect themselves. And when we have handbook provisions, we always tell our teachers, don't friend with people, don't connect with students and parents. And again, that's for their own good. So I know sometimes they push back and they're like, you can't tell us what to do, but it's actually for their own good because we've seen teachers fired because of things that are on social media. Yes?
So that would be out against the person who know they didn't specifically mention, chicks that move on school, or there was no counselor saying, specifically type 2 punishment to all that, again, just very
Right. Yeah, it can still be used against them. I mean, we'd be trying to keep it out. We'd be trying to say it's prejudicial, it's irrelevant, but I mean, it's going to be a question for the judge to decide what comes in and what comes out. And half the time, by the time you get to trial, everything's kind of been seen anyway, or the judge has seen it to make these decisions, and it's kind of tainted your case. So that's why you do want to just not have it. And like Michael said earlier, just tell them set your settings to private if they want to put, if they're in a band and, they do stuff that's, maybe, like we've seen some drug issues with teachers, using marijuana or using other drugs. So don't put that on Facebook if you're going to have things set to public.
I mean, keep in mind, in employment litigation, almost always what it comes down to is the state of mind of the decision maker. Was the decision maker considering inappropriate factors such as gender, race, etc.? And so if you can find any evidence to demonstrate, yes, this person does have an animus against a particular category of people, even if it's not tied to that plaintiff, it's going to be evidence that tends to show, well, if he's sexist in this context, why it's not that hard to believe that he's going to be sexist in this context.
Yes.
So I would say that this is like a perfect lawyer answer, right? Ready for it? Well, it depends. Right, it depends on what they're saying. If the student's post says, this person's an awful teacher and he, is late to class every day, no, we don't have any obligation to prevent that from being out there. If the student's post says something that's inappropriate, this guy's so old, he was probably alive when the dinosaurs were around, but, then now wait a minute, now this looks like potentially harassing conduct, and we do actually have an obligation to mitigate that for our employees, right? So, you'd have to look at what was specifically said. If there's something that relates to a protected category such that it could be harassing or discriminatory, yes, we would have an obligation to act in that context. We could discuss to what extent, but, if it's simply whether, true or not, a legitimate review of teaching style, then no, we wouldn't have any obligation.
But we actually do recommend with your students that you have something in your handbook that says things they do off campus can affect their enrollment. So that you would, it's very hard to get those things off those sites, I will tell you. Like, we struggle when we have something inappropriate to get those sites to take it down. But you could at least say to the student, look, and now again, like Michael said, if it's appropriate, they're a bad teacher, the teacher's got to kind of deal with it. But if it's something totally inappropriate, you could then use your handbook to say, look, we have the right to unenroll you, we're going to keep your money, do you want to take it down,
That website have to release the information to you? Like, if it's fuzzy stuff like 1, 2, 3 posting about me, you say, at least in your head, and you should read it. I mean, do they have, what is a website like this? There's a South calling me up and saying, oh, they went in with the president.
There are rights, but I will tell you, I mean, we've had postings where people have posted, like, pictures they took of people, like, in compromising positions that really shouldn't be posted. It's really hard to get those sites to take them. There's just, even getting them to respond to you, getting them to respond to legal letters. So it's something that can be legally done, but practically I find it's really hard. Even when we have litigation, we try to subpoena Google and places like that. It's like crickets.
Yeah.
Yeah. Right, okay. So another hypothetical, an independent school director has a private Facebook profile. She talks publicly about her school, the school her children attend, and touts her success in getting students into the best colleges. Several families apply for admission. So now again, she's talking about her own school. Anyone see an issue with this? And this is kind of a new area that we're... You're onto it, actually. You're onto it. So there's actually a Federal Trade Commission Act, which actually says that you have to disclose if you are connected with something. So if she's part of that school, she should really disclose that she has, she's employed with the school. If you're being paid by someone, you really need to disclose that you're a paid endorser. It's funny because it is meant to really apply to the influencers, but technically it applies to employees. So you just want them to know that they need to be careful what they post about the school, because as an employee, they should really be also disclosing that they're connected to the school. And we do recommend you put in your handbook something to the effect that they shouldn't be tying, connecting to your Facebook page to theirs. They shouldn't be putting something that's going to direct people there, because you don't want to be pulled into that. But yeah, it's a really interesting new issue that's coming up. Okay, so another thing that we're seeing in terms of social media, and we've talked about this in the past in terms of recommendations for people, and we try to recommend that you have a provision in your handbook that says if somebody calls for a reference, that you direct them to someone in HR. You don't want your supervisors giving out recommendations or endorsements to people willy-nilly. You want them to come to you, because then you're going to look to say, hey, we just fired John. We don't want to give him or her a good recommendation. We want to manage that. And maybe even just say we confirm the dates of employment and the fact of employment. Same thing is happening on social media. So your manager might love Kristen one day and put all this wonderful stuff about her, and then 3 months later she wants to fire Kristen because she's doing all this bad stuff. Well, that stuff that she put on Facebook and social media could be used as part of your case because she's now said good things or bad things about an employee. So again, these are just the weird ways that social media is kind of coming up, and you should be aware of. Yes, and actually we had a case recently with LinkedIn where someone put endorsements saying that he had certain degrees, and the school ended up contacting those schools and finding out more about the degrees, and they were actually weird degrees where they were accurate, but they're publicly they're mass degrees, so you just take an online course and you get it, and the way it was described was much more than that. So yeah, LinkedIn's definitely one of those places where we're seeing more of that. Yeah. Yes.
If I'm looking for a new position, and leaving under favorable terms, and I go to one of my coworkers and say, can I use you as a reference, as a good reference? Is that allowed? Or do I have to, and then they get the phone call, should they direct that call to HR?
So, as the representative of the school, I would like you to tell everybody that every reference request should go to HR or someone who's going to control it. Now, legally, does it matter? Like Michael and I are colleagues, we're equals. It's not going to matter so much because I don't really bind the school if I'm another third grade teacher and I say something good about the other third grade teacher. But I'd still rather, as a lawyer, not have it out there. And we've seen real litigation over this. I think I've mentioned in the past we had a case where we fired a teacher for poor performance, and they wrote her a glowing reference because the school was lovely and wanted her to, she wasn't the right fit for them, but they wanted her to get a different position, and it was the first exhibit to the complaint against us. So these things are definitely coming up in litigation. Yeah.
I mean, you can imagine how if you fired someone for performance, and our job as the attorney is to demonstrate to the court that that was a legitimate reason, that 6 letters from their colleagues about how great they are is going to hinder our ability in that litigation. Now, of course, if the person is a rock star and they just want to go and leave, it's going to be a lot harder to convince people that they shouldn't do what we've said they shouldn't do. And that's probably just the practical reality of it.
Did you want to take a little break for lunch now, or do you want us to? It's up to you guys.
That describes me generally.
Sure, you guys want to take a break and we'll come back in a little bit?
Like 10 minutes, you can get your lunch and grab everything.
So how are we doing with
Yeah. Hi, how are you?
Well, they should still, if that's your process, they should still give you a supervisor.
But we can still ask to speak to somebody in HR and like their current placement.
Well, so what we want you to do is so say I go to get another job and I put Michael down as a reference. I want Michael to go. I want Michael to go to HR,
right?
And say, hey, before I respond to Susan's the employer, what do you think?
Which is exactly what I would do.
Okay.
That's truly easier said than done. I mean, at a place like Phillips, we're all conditioned to be like, wait a minute, what should we do here?
Does that make sense?
It
though?
does. No, I mean,
Okay.
because I've even had people who left working for my friends. I've had people who left working for my friends and said, hey, can I use a reference?
Yeah.
And before I was in the HR department, I would have said, sure.
Right.
But in the back of my mind, I knew like I'm going to either tell my supervisor or tell
Right.
HR that
Yeah.
this person wants to use me as a reference.
Yeah.
Nobody's called me yet. It's just
Right,
Yeah.
and that's why we like you to have it in your handbook, because then that person like you can say, hey, I'd love to, but we have this restriction. Let me talk to HR and see if that's okay. If they're fine with it, I'd love to.
Yeah, I mean,
Kind of
if
gives
it's
them
a
some cover,
permission,
Yeah.
our school's kind of a funny place, like our HR department's really new. We used to be secrecy, and so
Oh,
now
perfect.
we're really now we're really trying to get people in these processes.
Right.
I just had a person who was like, oh, I've been getting reference checks all year long. And we're like, okay, we need you to send them
Right.
to us now. And so it's like making us really get out and hire the season.
Right.
To Susan's point, once you get to the point where you've established what the policy is,
Right.
that person can go to, if they're at Germantown and they want to go to Hill, they can say, okay, you know, let me direct you to so-and-so. Their policy is to only provide dates of employment. And, you know, after Hill calls 10 times, they'll get the drift, right? But, you know, if Hill calls the first 9 times and it's, oh yeah, this person was great, and they did this and they did that, and the 10th time it's like, her dates of employment were,
Yeah,
you know,
really have
that,
to have that policy so that even if they get call a department, the department knows when that reports HR.
Yes.
Yeah. That's fast. Now, like Michael said, it's not the end of the world if you get 1 or 2 reviews that slip by. It's more your supervisor that's really binding, and then if you get like 6,
Yeah.
you know, it's gonna start to look bad.
No, thank you.
Sure. Look at the line. Hi.
hi, how are you?
How are you?
How are
Good, how
you?
about yourself?
Good, thanks.
Maybe in need of your service. We use a firm that's not on the AIG list of firms that they are to represent us.
Okay.
You guys are.
Oh,
We are.
good.
We have an ADA complaint that I think is gonna go away. We're a small school, we have 25 employees. I think this is gonna go away, but into the future, now that I know our current labor guys can't be used, if we stay with AIG, I'd like to maybe look at the contact back and forth with you.
Yeah, that'd be
Yeah,
great.
definitely.
Do you have contact?
Yeah,
card or
we'll give you our
something?
cards.
Yeah.
Michael and I work together, so we don't.
Yeah, you know, when the woman on the phone mentioned Fisher Phillips, she mentioned 4 different firms.
Oh, funny.
You guys jumped right out because I've only been to one of these before.
Uh-huh.
And here's my
Oh,
only.
Thank you.
I remembered, I thought I remembered anyway, so.
Yeah.
Whether this goes any further or not, I think it's an amicable situation. My president happened to say something that he shouldn't have said.
Oh,
great.
right.
He's the only one above me that I can't say you jerk and
Right.
shit like that. But I
We
think
can.
yeah, you can, you know, and we use Ken Roos and Mary, they're from like Wilshire, Pearlstein or something like that.
Okay.
Yeah, and they're great people, and I
Yeah.
think we're gonna work this all out. But
Right.
it's not gonna get to the point where we need AIG to back us
Right.
and fund
Yeah,
us and
that's
the whole
good.
bit. But now that I'm aware of this, and should it, you know, go, I may have to say to my board meeting to not use who we're using.
Right.
If ever we have this problem again, because my president sometimes speaks before he.
Right.
So I-
Sounds like a separate conversation.
Yeah, it is.
Well,
and-
you're really
and
going
he's
to
really a
enjoy
good
the-
guy, but, you know, he's gonna get us in trouble down the line, so.
Yeah,
Great.
yeah.
Nice
Okay,
to meet you.
great, great. Hi, how are you?
How you doing?
How you doing?
Yes.
Oh, good. How'd it go? Oh, good. Uh-huh. Oh, good. That's great to have, though. That's good you're on top of that.
Okay.
So one thing.
Right. There's so much on your plate, though. It's so hard, huh? I mean,
I'm sorry. Give me 1 second.
right.
Can I interrupt very briefly?
Yeah.
When are we doing the hostile work environment presentation?
It was probably going to be third.
Third. Okay.
Third? Yeah, we were
What do
going
we
to.
had first?
Yeah. And these are all going to be available, too, so if you have to leave early, we
Yeah,
can,
I
you'll get
really-
the slides.
Yeah.
HR isn't my thing. It's just
Uh-huh.
when I saw
And,
hostile.
And if you
Right.
miss- If you miss all or
Okay,
something,
great. Yeah, so things are going well, though, for
you
you?
can take a look at the slides.
Oh, good.
Call us.
That's nice. Can you believe the year's almost over?
That led into the
Oh, yeah.
ADA. Like I said, I think it's.
You need the summer, huh? Right. Sure, sure.
I have a great rapport with her. You guys do so well with all the questions.
Oh, good. We love the questions. It makes it more interesting.
And there's clearly a need for this.
Yeah.
Just by the nature of the questions. So it's,
I think
Oh,
I do, but
No, it's
down the road, now that I know
Yeah.
they're
It's
covered,
I'm glad we're
they're
starting
they're not on their list of approved.
Yeah. It is really hard. I mean, I have to say, like, they deal with a crazy situation. Like,
Thanks.
you know, I might touch on this when we get to students, but like just the other day, a school called me and like some kid had taken pictures of herself because someone overseas had lured her into taking topless pictures, and so they're trying to deal with that. And then the kids shared them at school, and then the kids at school are sharing these topless pictures of the kid, and it's like, and the head is like, and the business officer like, what are we doing? Like, yeah. We're like, we just want to teach math and figure out if we focus on a STEM program or not.
Well, and to your point, getting it off is impossible. Like,
Right, yeah,
That's, I mean, you can wish it all you want.
right,
You might even have a legal case.
yeah.
But you're never.
They just ignore us. I mean, even
Yeah.
like lawyers, they just
Yeah.
ignore our letters and our,
Yeah.
you know.
Wouldn't you if you had the financial backing of Facebook?
Yeah,
or
I mean, I've
Google?
subpoenaed
it's
stuff and they're like, yeah.
I ignore
thank
stuff
you.
all the time, and I'm just
And it spreads
Me.
to 10 other places, like even if you find it in one.
yeah.
it's gonna
Well, that's
be-
the thing. Once it's out there,
Right.
anybody can get a hold of it.
Yeah, it's
Yeah.
kind of sad in a way because, like, with the kids, like, you feel like, look, guys, when you put this out there,
Yeah,
out
you
there
make a
forever,
mistake when
you
you're
know?
16. And
Yeah, it's hard to get that down.
Yeah, and that's, I mean, we obviously school spend a lot of time trying to educate kids about that, and it's, it'll come, but 10 more years from now, we'll be better at it, because those kids in that first iteration will be like, I wish I'd never done that. Now
Right.
they'll be adults.
Yeah.
yeah.
And they'll be
Or they'll
able to-
figure out
Yeah.
a way to have the technology prevent it, right?
Yeah,
Like,
they'll be,
you'll be able to give the phone to the kid, and the phone will recognize, oh, wait, this is a picture of X.
right,
Can't be taken.
Can't be taken.
Or can't be sent,
Can't
or
be
whatever. You
posted.
know,
And it's
somebody will
interesting
figure
too,
that
like with
out.
investigations, because like with that school, it's like, now don't take the phone and look at it, because then you have child pornography. So it's like, okay, we need to bring the police in.
Yeah.
oh, Jesus.
You know,
Yeah, I
because
didn't
it's
even
like,
think of that.
I was like, okay, what have you seen so far?
Ooh,
You know, yes, it's really interesting.
right, because of course
Yeah.
then you're talking about an administrative meeting, someone pops it up on the big
Right,
screen to talk
yeah.
about.
Or they take the phone. Okay, now what'd you do with the
Yeah.
phone?
Ooh, ooh.
Now
I
you
didn't
have
even think
possession
of
of
that.
pornography. Yeah, it's really interesting and hard.
It's
Now,
horrifying.
I didn't come up with a contingency plan for you guys. Did you want to sit and have a sandwich?
We should grab. Well, I'm fine waiting till the end.
Oh,
You
yeah.
want to go grab something?
Do you want to grab a sandwich?
No, I don't want to grab a sandwich.
Okay.
Thank you. I may see if you have cookies, though.
Yeah, you want to grab something that looks
Yeah,
like a
you
lot
know,
of
I'm
stuff?
13.
Yeah.
Yeah, I have no idea. I didn't order lunch. Ron's in charge of lunch.
Oh, he does a great job.
over there.
How's it going though? You guys have seemed really like very organized lately. Do you feel that way?
It's coming along.
Yeah?
It's getting better.
Okay.
It's getting better. Today was just a little nail biting because Sarah and Aggie are both out today.
Oh, I didn't know that.
So Ron and I are like,
Oh, was that a?
and this
was
is a
that
new thing. That response.
Right.
So, it's like, but no, everything's cool.
Everything's
Was that
fine.
a surprise
Nothing to
as
see
well?
you.
Was that what
Hi,
you
how are you?
Yeah, yeah. We just had, oh, no surprises.
Go ahead.
Hi. How are you? And I have been dying to meet this person. Okay. Just because there's so much.
Yeah.
They're dying to meet these guys.
Oh, geez, that's upsetting.
Oh, wow.
Wait, I mean,
We need to raise their
Yeah, they're both
expectations.
experienced.
the last 5
Yeah,
years.
yeah. You can always tell when you come to these that everybody's really interested. That's why I love doing this, because I do these, we stand up and 20% of the time everybody's just,
This group is like,
why am I here? Nobody's listening to me.
I'm fascinated. Having said, I mean, and it's a small coming violations.
Oh, God, it's so really bad and stuff, because they come to things. We were just talking about, like, the references. Yes, let's help you. That comes from a place that's nice, but at the end of the day, it's like, you can't say that.
Well, that's this all back on the States, all about. And just move these people. Apparently, there's something wrong.
Oh, goodness. Wow. Okay. Oh, wow. Okay. And what is he? His maintenance?
It's horrifying. Because my dad was the entire.
I bet he is. I bet he is. He's got to be really good for him. Now, do they have a home?
Yeah.
Yes. No, my dad lives on campus.
Oh,
Yeah.
because that's always, I watch retirement.
What's the reason you just don't want to like say that campus or you're terminated?
I mean, he lives
Guy otherwise.
probably 600 yards from campus.
Yeah.
You know, so that'll be nice that he'll still, you know, he has a bunch of friends that have retired over the years, and he's been there for 29 years, so, you know, he's already started going,
Search on that.
Thursday night beer club at the
He's embracing his retirement.
Yep.
That's awesome.
He's going to very much enjoy that aspect of it. Mom passed away last fall. So he had gone back to school and basically said, like, you know, the plan was for him to retire at the end of next year. She was under He's like, well, I'll go back and see if I feel like staying. He was back for a week. He's like,
Right.
Good for him.
I don't want to work anymore. I don't need to.
Good for him.
It's like, geez, man, it wouldn't have even been a question for me. Like, working versus
Yeah, I
not
was going to say.
working versus not.
This is, this is a fun job.
Right? Any job. I don't care what you do. If you love it so much that you'd rather do that than not do that, then yeah. We need to talk. Exactly.
So, I mean, that's you understand what it is a gray area. It's technically right. You don't need to do it unless they have to do it. However, I'm not going to say because you do it inside there's an issue. So if you did something, you had to sit on the stand and say, well, we kind of thought about it, hinted that he had an issue. I think if you should tell me, but I think if the girl knows you might have wrong,
Okay.
they might shot them because I think people. So I mean, I would definitely do it.
Go with it.
Legally, legally, but because I think what will happen is, you know.
That sounds right.
Okay.
It is always nice to feel like people are together.
Yeah. I do. Well, that's just, I was gonna say, this stuff. Yeah, you guys, this is always the best part. It's gonna prevent you from applying to school or. Okay.
I think it's a huge need. And I think there is so
Could you have like an educational discussion? You know, it's not like dates.
whatever it is. So this gives them the ammunition to try to
Yeah, I mean, even just being able to print this off and say, like, look,
This right here.
Guys gotta read it, how many food is flying out of here?
Are there cookies?
that's all
Oh,
right.
yeah, like it's yours. Oh, yeah, definitely.
Oh, no, don't go into the right.
It's right behind the wall.
Look at me. Do I look like the kind of guy that needs it?
I understand that. Well,
Say want.
I understand that. Well, it wasn't need.
Great. I think it was Michael, so we gotta get him more inside.
And one salad.
They're talking cookies, so.
No, don't worry about it. So I'll do my best to talk at you while you eat lunch, and I'll wait for people to have their mouths full to call on them.
Switch the slide on you. Just
Oh, that's all right. You know, one funny thing I was thinking about when I was looking at this slide cover page during lunch break was that one of the laments I've heard from an in-house counsel at a college that we represent is that over the past 5 years, he said, you can't believe how many calls I get from parents of students who have seen their kids on social media doing something, and they call me and they say, well, I saw a picture of my kid drinking at a fraternity house. What are you going to do about it? He's like, well, nothing. Your kid goes to college. I mean, we're not going to police their behavior like that. But he said you wouldn't believe how many parents are watching this stuff from afar and calling. Imagine calling the college's attorney to yell at him about your kid's behavior on social media. But, you know, obviously that's sort of a microcosm of the change that I'm sure you've all seen and that certainly he's seen over the last several years in students' usage of social media. We're going to start with a case study. Erica is in 10th grade. She and about 20 other kids end up at John's house on the weekend when his parents are gone. Some kids, including Erica, drink and smoke some weed. Erica has some memory of the evening, but is not sure what is real and what was a dream. The next day, Erica hears that several students received a video of her without her top on. Girls at the school start calling her a slut on social media. What are some of the issues raised by this hypothetical? Oh, yes. Well, how many of you have bullying policies? Certainly, this would be a situation that would call that policy into question. We're going to talk about child abuse later. This would be a situation where that would be implicated. I don't know if we're going to touch on issues related to sexting. I think that's later. That's later. Obviously, that would call this into question. Child pornography possession. If Erica's in 10th grade, she's likely not 18. Pictures of her with her top off would be criminal in that context as well. So obviously, this hypothetical brings a number of issues into play. You know, I discussed this briefly earlier, but the First Amendment is not applicable to private schools in this context. There is no First Amendment right that your students or your faculty have to say or do whatever they want. The other thing that this hypothetical brings into question is, well, wait a minute. If these kids are at John's parents' house and they're using Facebook, and we don't control Facebook and we don't control John's parents' house, why is this our problem? You know, we just talked about a number of reasons why that would still be something the school would want to focus on. And of course, the question of whether or not the school can discipline the students, you know, yes, of course you can. Certainly, you'd want to make sure that your contract made it clear that that was appropriate. Oh, I'm going to talk about sexting right now. So sexting is when a minor sends an image of another minor over the internet reflecting nudity, partial nudity, or depicting lewd or sexual acts. It's a violation of Pennsylvania law and most states' laws. We will talk a little bit more about child abuse later, but it may also constitute child abuse, where the video is distributed to a number of people, depending upon who's a recipient, who's the taker, etc. There are also issues that could, where there could be coercion at play, and then, you know, once the school learns of this conduct, we'll talk about in our child abuse reporting section, they may actually have an obligation to report that to the state.
And let me just emphasize that last point, because we're seeing a lot of sexting, and a lot of it is really impacting schools, because someone's sexting on the weekend, but then you come in on Monday and everybody's talking about it, they're sending it to each other, and the school has to take action and should take action. But you have to really think about this, and we're really recommending that you bring the police in, because you don't want to start taking possession of those phones, start getting the images sent to you. Now you possess child pornography. So you really want to bring the police in, let them, you know, assess the situation, do your investigation in conjunction with them. You're not just going to turn it over, but really bring them in and have them guide you through this, because sexting is really a tricky area, especially with, you know, child pornography laws in addition.
And not only that, you want to make it clear to your students that, you know, if in the context where this 10th grader has this picture taken, if you're an 18-year-old senior and that gets sent to you, well, now you're in some serious potential hot water for a number of reasons, including possession of child pornography.
So it's just sexting on a minor, like you said, if it's a minor to 18-year-old.
Those are much more serious crimes. That's not to suggest that it's not a crime. It's just a much more serious crime for the 18-year-old and above to possess the video or have taken the video or have coerced the person into the behavior. You know, then you get into child pornography and various, you know, sexual assault statutes in those contexts. Yes, ma'am.
How does it change if student sexting?
It's still against the law. That would still be sexting. Even so, if she was at the party in the hypothetical, took the picture of herself and started sending it to people, that would still be a violation of the law. Now, depending upon who that may change our analysis with what the recipient has done wrong, right? You know, if she sends that in a text to an 18-year-old student and he deletes it and he's like, well, wait a minute, you know, perhaps that's not going to imply, you know, bring into question some child pornography or other issue with respect to that student, but her sending of the sex would still be problematic.
And you really want to think about these issues when you're drafting your handbook policies, because you really want to give yourself a lot of discretion as to how you handle these. We just had one of these last week where a student was kind of tricked into sending pictures of herself to someone overseas, and then somehow the other kids found out about it, and they were exchanging those pictures, and there's a group that was doing it really. Some kids were actually concerned for her because I think she was a little disturbed, had some mental health issues, but then other kids got a hold of them and started sending them, not in a nice way, not to help her. And so the school really had to step in, again, involve the police, but dealt with it every situation separately. The first kid or two that was trying to help this kid, maybe you're not going to discipline that kid. You're going to provide some counseling, help them through it, but then maybe you're going to, discipline the kids who are just sending it just to be jerks. So you want to give yourself a lot of leeway in how you handle these situations because they're very complicated. And obviously the child who was tricked into sending the images was very traumatized. So we had to really work through how do we address her situation and protect her.
And you can see in the second bullet point that the school's obligation to act exists irrespective of when the actual behavior occurred. If the school found out about it 3, 6, 9 months later, once you find out about it, you still have that obligation to report it under the state's child abuse laws. You still want to get the law enforcement involved, et cetera. Yes?
I have a question on the school obligation.
Mm-hmm. You're on the hot seat, Justin.
How much information I should provide. So the incident was employee shared an image of genitalia with a group of students in a cartoonish way that the employee thought was light and funny, and subsequently realized very quickly that it was a very serious issue. That's what happened.
And so he is no longer with us. And my follow-up question is, when we have his potential future employers come to us asking if he ever conducted any or engaged in any misconduct, or because this is kind of a sexual nature, what are our responsibilities to disclose what happened?
Yeah, so, you're going to have to look at the Act 168 questions very carefully when you're responding to them. And I don't have those in front of me, but I would really be careful because that might be implicated. And I actually don't know if the vendor has those. But in terms of, so he sent pictures of like a cartoon.
Essentially a drawing. It was a trick on a drawing. It looks like one thing.
Like
Okay.
you draw
Do something
certain things
small.
on your hand, and then if
Okay.
you maneuver your hands in a certain way, it becomes a different picture.
Right. So I don't think you would have to disclose, there's a concept of passing the trash, like you don't want to, the law doesn't want you to hide that stuff anymore. And that's what Act 168 is trying to get at. I don't think you would have to disclose that, but it is borderline, I don't know, does anybody have any experience with similar? Yeah, I wouldn't disclose, I wouldn't say you had to, but it's a really gray area.
He wasn't convicted of anything, he was just let go from our.
Yeah, but I think some of the 168 questions go to whether they were discharged when there was a circumstance of investigation of a sexual nature. So, I would just really pay attention to those when you fill that out.
Maybe consult your lawyer.
Yeah.
Okay, thank you.
Justin, any other things you want to talk about?
You hear something interesting and new every day. Okay, and then obviously we've talked a little bit about how the age of both the sender and the recipient may affect the legal analysis. If the sender is over the age of 18, the behavior may be prosecuted as distribution of child pornography, which is a much more serious offense. That's a Megan's Law reporting offense. We talked a little bit as well about how the hypothetical implicated our bullying / harassment policies. I would presume most of the schools have bullying policies. I would presume most of the schools here, if not all of them, have policies that relate to harassment. Obviously, sharing a nude photo of a student and then calling her a slut amongst the student population would implicate both of those policies. And as Susan, I think, has said a couple of times, you really want to make sure that those policies, A, make it clear that this type of behavior is covered, and B, make it clear that the school has the discretion to discipline for that type of behavior, including requiring the student's withdrawal.
You need to see it yourself to act on that. Like, say something
No,
that's
I in fact think.
They look at as almost slut on Instagram.
Wait,
Oh,
say your
that's.
question again?
So
I thought you meant the picture.
A parent would, no, not the picture. A parent would report that they saw their child's phone, that on Instagram they called, this is the girl's post. We need to see that. We need to see the Instagram post.
I mean,
Act on it.
Or
no,
you
you.
want to do an investigation, so you'd want to bring those kids in separately, you know, Kristen, what did you see, Daniel, what did you see, and try to understand what happened, you know, ask, you know, obviously if you have that, that's the best, because then there can't be any he said, she said.
Ask for that from the kids?
Well, the person who's complaining should definitely show it to you,
Okay.
yeah.
I mean, to the extent that you can get documentation or documentary evidence in any context, that's always going to be our preference, right? Because you can imagine if there was some challenge to the action by the school based on an Instagram post, and we didn't have the Instagram post, start to think, well, wait a minute, you know, how did you conclude that that had happened? Now, that doesn't mean you can't come to that conclusion through an investigation, as Susan said. So, you know, there are going to be times where that behavior is engaged in person, right? So-and-so called me this in the hallway. Okay, well, then you do a normal investigation like you would in any other situation. You know, who was there? Did anybody hear it? You know, and you talk to those people. Well, 3 students who were standing there heard you say it. You know, therefore, we conclude you did it. Therefore, under the policy, here's, you know, the discipline, you know, or the result of that. But certainly, I would ask for documentation in that regard. Now, obviously, to Susan's point earlier, if we're talking about the picture, you know, don't ask for that. That's when you get the police involved. Let them conduct the investigation into the actual, you know, potential naked photograph of a minor, right? You know, you don't want to ask for that. But if it's a post where there's a comment that's inappropriate, I would certainly get a copy of that. That's a great question. I don't know that I've ever dealt with that.
Police get
The photo?
Yeah, I was looking at you could drag out the whole school year. Starting September, and I can't stop.
Oh, no, I suspect the police would be able to get the photo very quickly.
Yeah,
Yeah.
I mean, they seem to be very on top of it. It's more just the question of, you know, like in my example with the student, she had the pictures and she knew who had received them. I just don't want the school to have the pictures of her. I want the police to see that, and then, you know, they can get, you know, I don't know what their official process is, but they were able to get all of the others' phones and find out what was on them, so.
I mean, you know, the police are, A, going to show up and ask for it, and if they get it, that very quick, and B, they can always get warrants for those things, and that's a very quick process as well. So I would suspect that they'll have an answer to you, especially something as severe as that, you know, pretty quickly. Sorry.
Okay, so we talked about some of these already, but just some tips for your social media policies. So you do want to have a policy, and you want to realize that there are many different laws that apply, but try to be a little bit realistic. You know, your employees are going to use these sites. I see a lot of handbooks that say you can't use any social media on campus. Okay, but I mean, I'm sure all of your employees are checking their phones at some point, so just be careful because, you know, you don't want to end up firing someone for that if you haven't, you know, enforced it against everyone. This is where we have the slide, ignorance can be helpful, so, you know, don't go looking for too much stuff, but if it comes to you, you do need to deal with it. When you're doing those hiring decisions, maybe consider limiting yourself to professional sites, but again, the most important thing is to be consistent with how you do it. Publisher policies have evidence that your handbook's been reviewed, they've signed off on it, they understand it. Train your managers, educate your teachers. This is all easy stuff, right? Just educate your teachers. But try to do what you can to make sure everybody understands your handbook and the policies. So again, this is pretty straightforward stuff, but you should have a social media policy that explains what it is, to who it applies, where it applies. You know, kids especially think that they have a right to put anything they want outside on social media, and you want to make sure that it's clear to everyone, even the parent who's probably going to read this when you have discipline issues, that you can discipline for things that are on social media. So even though legally you have the right to do that, it's helpful to put in your handbook. Require respectful conduct, forbid malicious, obscene, threatening behavior, and use examples when you can. So make sure that everybody understands that this applies to cell phones, iPhones, iPads, that information between, so some of these are for employees and some are for students. So make sure that your employees know that student information is confidential and they shouldn't be sharing that. They shouldn't be putting images of the kids on their own Facebook page. And that's, you know, something our teachers do to be nice. I mean, they had a great field trip, everybody had fun, they post some pictures. You just want to make sure they understand they can't do that. That needs to be done through the school. And then we touched on this, require school staff managers to use disclaimers and identify themselves as school employees if writing about the school. Make sure that they're clear they're not speaking on behalf of the school. And then use of social media at work. I mean, I do think you want to put something in your social media policy about not using it or not letting it interfere with your job, but just be careful about disciplining for it because it's very likely they're all using it. So again, remind employees and students that online sites are in the public domain. Off-duty, and this is the most important thing, is just make sure both your employees and your students know that things they do off-campus can affect their discipline at the school and their enrollment at the school, because you want to have that right to say, especially we enforce enrollment contracts sometimes, and we want to be able to say, hey, look, Johnny's not coming back for the rest of the semester, and we're keeping your money. Because as we say in our enrollment policy and in our handbook, we have the right to discipline for this, and we're doing so. And then require compliance with existing policies. Michael touched on this, but make sure they understand they can't harass another employee off campus or through social media. Anti-violence and threats, anti-bullying policies, confidential and privacy policies. And the last one I'll just mention, you also want to put in your handbook something saying that you will investigate. You have the right to look at things that are brought onto the campus. You have the right to go through bags. And you are going to cooperate with the police if something comes up so that they know that, you know, if you find out about sexting on campus, you're going to bring the police in and that's going to be shared with the authorities. So you also want to have policy, oh, sorry, Michael, this is yours. But let me just mention one thing about student handbook policies is I'm seeing a lot of handbooks that say we will not tolerate any e-cigarettes or vaping. And just be very careful with that because I think that would eliminate half of my high school students from all my schools. And that's okay to have in your policy, but you know I've seen schools do progressive discipline where the first time you're caught it's one thing and the second time it's expulsion, and you know if you put that in there you need to do it. And I mean I think half of our high school students have e-cigarettes or Juuls in their pockets, so just be a little careful with that. I know it's easy for us as adults to see that's terrible and you shouldn't be doing it, but just be careful. If you put in your handbook you're kind of binding yourself now to your policy.
Yes.
You know, I think it's very young. I mean, I think sometimes they don't know what they're sending, but they're still involved in it. And we had a situation just last week where the kids went on a field trip. And these were young boys, 4 boys in a room, and one of them took out his private parts and was manipulating them in front of the other kids and even grabbed a kid and put his hand down the kid's pants and was like in his butt area. I mean, and these were kind of like, I think they were 8 and 9-year-olds, you know? So obviously the reaction is going to be different based on the age, but they're really doing unusual things that you'd be surprised. And maybe that's because of the accessibility of stuff on the internet. They're seeing more and they're more, but.
I think also over the past several years, the age at which kids get I got my first cell phone when I was 21. That's probably not consistent with what kids are doing now, right? So the younger they are getting these things, the more you're going to see it with the kids that have the cell phone, right? It's having access to the medium is 90% of the problem. Okay, so we talked about policies with respect to employees. Obviously, we want to make sure that our policies that are applicable to students make it clear that on and off campus behavior can subject them to discipline. Make it clear that we prohibit bullying and harassment. Make it clear that the types of behaviors we've talked about with respect to sexting and sharing videos and stuff of that nature would violate the bullying and harassment policies, and make it clear that we have the right to inspect anything that a kid brings to campus. Obviously, there are also some legal issues with respect to the use of photographs and whether it's being used commercially, who took the picture, what privacy expectations there are, and perceptions in the parent community. We want to have a policy that delineates when and how we're allowed to use pictures, when and how our teachers are allowed to use pictures. We should also have the parent handbook and the student handbook make it clear that, the school reserves the right to post pictures of, your kids in athletic competition or whatever the case may be on the website, and ensure that the parents are signing off on your ability to use those types of photographs in your promotional material or on your website or Facebook page. Again, nowadays, because social media is so ubiquitous, on a Saturday, I'll get my Twitter feed will show the football team, and it'll show the soccer team, and, have the scores and all of that stuff from my high school, whereas 20 years ago, you got the one magazine every quarter, right? So make sure that all of those places where you have these policies make it clear that you're allowed to use the photographs in those contexts. Yes? That's a great question. I think about it, like I said earlier, my dad is a teacher at the academy, and you could imagine drafting a policy that's like, you can't post pictures of students, and then we go to Disney World, and there are pictures of me that he posts, and that would violate the policy. Certainly you could craft your policies to make it clear that they're not intended to apply to teachers and their children, right? The more you open the door, though, the harder that's going to be to enforce, right? So if you said, obviously the way teachers at the school interact with their children is going to be different, I would limit it there, right? And not say or if they're in a social setting and their kids are there and their kids' friends are there, let's draw a very clear line that's easy to explain.
And legally, that's probably not going to be a problem. And you actually do have a pretty wide ability to post pictures that you take in public areas. So like Michael and I went outside and I took his picture, I could post it. Like there's nothing that restricts that. But you guys also have to be more careful because sometimes it's a community problem. So like in your case, it's fine because your friend's fine with it. But sometimes parents don't want, especially parents are very concerned about their kids being subject to like predators. So they don't want their kids on. So that's where you want to tell your employees, just don't do it because we don't want to have those issues. Right.
But just thinking about parents who are out and they're in a social setting and not thinking it's not related to school, but they're just out and still.
Yeah, I think they would be fine, but that's a good question. You guys have different considerations because you often have community problems, not just legal problems, but like, how am I going to manage this?
Right.
Yeah. Do you guys want to take a break while we switch over to, we're going to talk about leave issues next. Do you want to take a 5-minute break while we switch over, or just keep going? Okay. Do you know how we pull it up, Michael? Let's see.
Oh boy, they made that really idiot.
Oh, here we go. Wow, they really did. Where's slideshow? Here we go. I feel like you should talk about your puzzle since you like that puzzle.
Oh yeah, I will. I totally drank your water, and so I took it away and put another bottle there. I walked in and I was like, crap. I'm like, I don't want you to drink after me. 'cause
Oh,
I'm
that's funny.
trying to avoid this cold.
So you took your thing off? Your thing
Yes,
off?
so I
Okay.
took my plastic off and I removed your cold bottle. So I drank after you. Hopefully you're not sick.
Not sick.
Yes.
I'll make a quick announcement while we're just switching over to the next slide deck. So if you did not sign up for HR Day 2 through the PAISBOA website, and you do want to receive SHRM credits, you just need to let me know before you scoot out today, and I'll make sure I get your name and contact information to take care of that. Thanks. Thanks, team. Sure.
I should have let him break, huh?
Yes.
I know.
You guys were so good. It was so easy to get to the next presentation. I thought we were going to. I know.
Yeah.
What happened with that? What happened? Like, wow. Okay. Great.
Made a foolproof.
You're doing leave now? All right, awesome.
Yeah. They need a vote. So. Or sugar.
I'm going to need someone to stop at the next meeting.
Yeah.
Do you want me to go? Should I wait a minute? Okay. So we're going to move on to speaking about employee leaves of absence. And I'm stepping on Susan's toes a little here to talk about this slide because this is like my favorite slide that we've ever used in any of our presentations for a very specific reason. It is the perfect way to think about employee leave laws and how that they don't exist in a vacuum. Each one of these laws has some interplay with the other, and when you're evaluating FMLA issues, for instance, you can't ignore the ADA. When there's a workers' comp issue, you can't ignore how that implicates the FMLA. And this is a great way to visualize how all of these statutes work with each other to really make your lives more complicated.
Great. So this is just giving you some background. I'm sure you guys are all aware of this, but some of these laws are the ones that intersect, deal with attendance. And so you have, and leave, whether you have to give leave and when do you give that leave. And so some of these are the Americans with Disabilities Act and amendments, FMLA, Workers' Comp, Uniform Services Employment and Reemployment Rights Act, and state and local leave laws. And you really have to check all of those, especially when you have an employee who's asking for some kind of accommodation or leave, because all of these can require you to do certain things. So managing FMLA and ADA leaves. So these are different provisions, and you need to make sure that you're covering them differently. So FMLA, you probably are familiar with, 12 weeks of unpaid leave. So we get that question a lot. It's unpaid. You can designate FMLA to run concurrently with other leaves, and that's a good thing to do and something you should put in your handbook. But do not count absences against employees automatically. And so does anybody have like a no-fault attendance policy? Do you have anything like that? Now, I don't see those a lot in schools. But basically, you want to make sure that your policy is not going to automatically, yes?
I have an odd question. If you have family medical leave for migraines, this was a situation we came across. They have their family medical leave for migraine, and you mandate that they call out family medical leave. You say it's family medical leave, but in the email they go, I'm out because I have a migraine. Under the family medical leave.
I would say almost certainly you should count that as family leave, family medical leave. Because you can imagine, although potentially, technically, you could say, oh, you didn't follow the proper procedure, you can imagine how that's actually going to sound to a judge or a jury. That you knew that they had migraines, you knew that that's why they had FMLA leave, and yet you denied their FMLA that day because they didn't say FMLA, they said migraine. That, especially in the context of a condition which actually affects your brain, right? So you can imagine that being that exact in that context is going to be really tough to stand in front of a judge or a jury and make that argument. Even if we could say, well, technically, the law allows us to implement call-out procedures, and this call-out procedure was you had to say FMLA, and she didn't in this context, that's just, the jury's going to look at you and say, no. You get out of here.
Does that answer your question? Yeah? Okay.
Okay. Okay. So as opposed to the FMLA, which is 12 weeks, the ADA has no set period of leave. And so that's a challenging one for us because, you know, judges and courts make us do quite a bit to accommodate disabilities, and sometimes that can be a prolonged amount of leave.
Let me run back to that question one more time. What you could do is you could respond to the employee that sent you the email saying they're out for migraines and just say, are you using an FMLA day? You could do that. Because then if they say no, well, okay, you know, you don't have to make them take it in that context, right? You know, you could reach back out and say, oh, is this an FMLA day? And then base your decision on that. So that may be one way to figure out the answer to the question, but I wouldn't just, like I said earlier, I wouldn't just use the technicality. Sorry to go back to that, but. Oh, yeah, you can. You don't have to, is my point.
Yeah. Yeah, no, there's some.
If you want it to be, right? So there may be a context in which you actually, let's say this employee's had 30 unexcused absences and you told them the next unexcused absences you're going to get fired, right? And you write back and you say, are you using FMLA for this? And they say, no. Okay, it's an unexcused absence. We warned you. We're going to terminate you based on this. Okay, so like there may be a context where you don't want it to be FMLA, but generally speaking, you always want to exhaust FMLA as quickly as possible.
And just so you know, there's a little caveat to that situation you just mentioned, which is, so for example, we had a case where an employee was out for a serious medical condition of their parent, and so it was FMLA. The school didn't do the paperwork right, but they want to go back and designate it, and that's okay to do. But you have to make sure that it's not going to disadvantage the employee, because then the employee could say they should get more leave. So in that situation, we had to think about it, because if the employee said, well, hey, if I had known you were starting my FMLA leave at that point, I would have maybe had my brother watch my mom for 3 days a week and only done 3 days and dragged it out more. They didn't. They were cooperative, and it worked out fine. But just be careful. It's not like an absolute right to go back and stamp it, you know.
Well, I mean, you're always going to want to get the paperwork eventually. You can certainly conditionally designate the time as approved. So we're going to talk in a few minutes about the notices that you're obligated to give the employee. So you can say, hey, you've requested FMLA leave. You're eligible for FMLA leave. We're going to conditionally designate your time away as FMLA pending receipt of the completed paperwork. But if the employee fails or refuses to return the paperwork, we want to have a much different discussion about what the appropriate reaction is, because in that context, let's say they missed 2 months of work and they never justified that with paperwork. You don't want to designate that as FMLA leave. You want to discipline that under your attendance policy, right? So you want to tell them, yes, this is a conditional designation subject to our receipt. You get the paperwork. It supports the 2 weeks that they've already been out. Great. We've already counted those 2 weeks. We're going to start from there. But if the paperwork doesn't come back, I see very few instances where I would say go ahead and designate it as leave and excuse it without some sort of justification through the medical paperwork. Does that make sense?
And I really agree with, I wouldn't want you to ever do it, because say the next person says, well, I want to hop on 1 foot and I want that to be FMLA leave. I can't hop on 1 foot today. Like, but they happen to be pregnant. Like, you want to say, well, they just rubber stamped it this time, but now I want paperwork from you. You want to be treating them consistently. So yeah, I would give it to them temporarily and, you know, while they got the paperwork in, but I would never say, you don't need to ever give me the paperwork.
Yes.
Now I can just terminate you.
Yeah, I mean, there are So the regulations for the FMLA set forth deadlines for returning paperwork, and then you have an obligation if they don't return the deadline, they don't return the paperwork within the initial 15-day deadline, they have 7 days to amend or correct that deficiency. You have to send them notice that they have that time. If they just refuse to give you paperwork, even if it was a legitimate reason, yes, you can deny their request for leave and discipline for absences because those absences are unprotected. Now, if you have some reason to suspect or have some knowledge as to a legitimate reason that they couldn't return paperwork in that time frame, and to use a silly example, let's say you get a call that the employee was in a car accident and they're in a coma. Like, we're not going to terminate them for unexcused absences because they couldn't get us paperwork while they were in a coma, right? But if there's nothing to suggest an inability to get the paperwork, if there's nothing coming from the employee saying, hey, I have a doctor's appointment scheduled for 2 days from now, but I couldn't get in before then, can I have an extension of the deadline? If there's nothing like that, yeah, oh, absolutely, you can deny and discipline for that under the ADA and FMLA.
In that same instance, you don't get any feedback, but then the individual returns to work with the need to return to work.
So we're entitled to the certification of healthcare provider. If you receive a note that contains all of the information that would be on that form, but it's not in that particular form, I would probably say, yeah, we have the information we need. Let's not have form over substance. Let's not focus on that, right? But if the note just says, please excuse the employee's absences, she was sick, well, that's not sufficient information to actually conduct an analysis under the FMLA. Yep. So FMLA, 50 employees within a 75-mile radius. ADA is 15. Very important to remember, the PHRA is 3 or more. So the Pennsylvania Human Relations Act, which is going to obligate you to accommodate in the same way that the ADA does. So you're all certainly covered by Pennsylvania's, if you're in Pennsylvania, by Pennsylvania state law. I don't know Jersey's numbers off the top of my head. I think their anti-discrimination and accommodation statute is like 1 or more employee. I forget what their their Family Leave Act covers. It may be 50 as well. So if you're in Pennsylvania and we have an ADA style issue, even if you only have 12 employees, yeah, you're still going to have to go through that same analysis because state law is going to obligate it. When you're if you have, let's say you have 40 full-time employees and 20 employees who work 20 hours a day, that counts as 50 employees under the FMLA, because we're looking at, under all these laws, we're looking at full-time equivalent. Yes. Oh, it's you. Oh, I don't know. I didn't go to the next one.
Okay. Okay, so some things to be concerned about that the EEOC has focused on are inflexible leave policies, requiring employees to return to work without restrictions. So, like, again, that's saying you can't just say you have to come back to work without restrictions. If they can come back with reasonable accommodations, that's something you should entertain. Failing to have an accommodation policy. And that's actually for your protection too. You want to have something in your handbook saying if you need an accommodation, come to HR, come to the business office and let us know. Because then if they don't do that, we at least have that extra argument. We had no idea that he or she needed an accommodation. We say right in our handbook to come let us know. We'll engage in the interactive process. So that's actually for you as well. And then counting FMLA and ADA protected absences under attendance policy. So again, you don't want to sanction them for taking protected leave. So a case study, you find out from your upper school division head in late March that she is not going to offer a contract to the performing arts teacher due to excessive absenteeism. You are not aware of the absenteeism and ask for the details. You find out that the teacher has missed 31 days of work since January. When you ask why, no one knows. The teacher did not have an attendance problem in prior years. You look in the file and see a medical note relating to the teacher's need for surgery and rehabilitation. Any thoughts on this? So would you just terminate this person? No. Okay. So you'd want to do some investigation, find out what's happening. It's likely someone dropped the ball here, and there should have been some paperwork done along the way. Just to remind everyone that not renewing a contract is the same as termination. We always say that, but sometimes we forget that, and we think that, oh, I'm just not going to renew. That's totally different, but the law looks at it as a termination.
And I think it's also important to keep in mind that the FMLA and the ADA don't require some sort of magic words from the employee to implicate the applicability of the statute. So clearly at some point in the context of this hypothetical, somebody became aware that this person needed FMLA leave, right? Or ADA leave, if that's the context that we're dealing with. You know,
That's a really good point that I would just want to repeat, because we've talked about this with performance management, so this comes up a lot in that context. You know, you have an employee who's not performing well, and you can't just treat it as a performance problem. If there's something that tees you up that this could be some type of serious medical condition or a disability, you want to have that conversation.
So all the employee has to do is put you on notice of his or her need for FMLA leave, or under the ADA, his or her need for an accommodation. They don't have to use the word FMLA, they don't have to use the word accommodation, but clearly in the context of this hypothetical, they've given someone enough information to make it clear that there was an FMLA or ADA issue potentially. That's actually one of the things that is critical to discuss with managerial level employees, is that we are going to rely on those individuals to communicate that information to human resources. Very frequently, like in the context of that hypo, the person has told their manager, well, I have to have surgery. Well, my mother's sick. Well, you know, I'm dealing with this condition. And the manager has not elevated that to human resources. And that's when we get into huge messes, because the case ends up sounding like this. You terminated me for absences that you knew should have been protected by the FMLA. And then we look into it and we say, well, oh shoot, they did tell us. You know, here's the note in the file that said they needed to have surgery. You know, this is a huge problem. So your managers really need to be aware that that type of information needs to get escalated up through human resources, so that the folks in this room can handle it appropriately as the law requires. Yes, ma'am.
So what if you have an employee who has provided you enough information to say that they may need a reasonable accommodation?
Yes.
You have had that conversation with them, and you have said, these are the guidelines and process of making that reasonable accommodation, and you just have continued to not. How do you advise us to think of that, and they're not doing what we would prefer them to do in order to get sort of that reasonable accommodation?
Sure. So if the employees come to you and made it clear that they need that, and you've responded and said, hey, it sounds like you may need a reasonable accommodation. Attached is a form to have your doctor complete that will allow us to evaluate your need for a reasonable accommodation. Please return the paperwork in 15 days, and then we'll go from there. And they haven't returned it, and you say, hey, you know, you need to give me that paperwork. If you don't give me the paperwork, you know, I can't excuse your absences, for instance. And they don't return it, well, there's nothing that would prevent you from moving forward with the disciplinary process. What can be very frustrating is you'll go through that, and then you'll actually issue the written discipline, and then they'll say, oh, well, I'll go get the paper. In theory, you could conceivably still leave that discipline in place. In practice, you may want to consider whether or not that's the best answer, simply because we will be in litigation potentially, and we'll have to acknowledge that, yes, we disciplined knowing that there was a potential accommodation, but their refusal to get the paperwork in a timely fashion resulted in the discipline. That's perfectly legal, but you know, it's not the most sympathetic position to be in. So that's just a decision to make at the time. So FMLA is applicable for the birth or placement of a child. Placement generally refers to adoption. The employee's own serious health condition, which can include inpatient care or continuing treatment, and then the serious health condition of a family member. Do we have any Jersey schools in here? Yes.
Immediate family member, isn't it more narrow than that? Because I don't think your brother or your sister qualifies.
Right, it's parent or children. Yeah.
That's a good point.
You have a better relationship with your sister than I. No, I'm just kidding. 4 types of notice we talked about. Are there any Jersey schools in here? Great, that makes it much easier. There's 4 types of notice obligation the employer has to give. General notice, that's the poster that I hope you all have in a break room somewhere. That's one of the 700 other posters you have that's this big. Eligibility notice, when you find out that somebody needs leave, you have to give them a document that says whether or not they're eligible. Eligible here means you have worked for the employer for at least a year and for 1,250 hours. If it's less than a year or greater than a year but less than 1,250 hours in the preceding year, the employee is not eligible for leave in that context, and you'd have to give notice that they weren't eligible then.
I just want to emphasize that you do have to post the notices, and they should be in your handbook, because I had a business officer recently tell me that the head wanted to take that stuff out of the handbook because it was too long. You do need to have it in there.
Yeah, if you see somebody in the break room taking the poster down, staple it back up. Rights and responsibilities notice, that's a notice that tells the employee what their rights are and what their responsibilities are. In this context, generally, that's going to include the certification of healthcare provider and then an indication that they have 15 days to return the completed form. And then once you get through the paperwork process, you have to designate their leave, meaning, hey, we got your paperwork. It says you need 12 weeks of leave for the birth of your child. We're designating your leave as FMLA leave starting September 1st through December 1st. Wait, yeah. What are the employee's notice obligations? If the leave is foreseeable, the employee has to give 30 days notice. Generally speaking, the birth of a child is a foreseeable event, right, which would obligate you to give 30 days notice. If I'm going to have a knee replacement done and that's scheduled for June 15th, I have to give my employer 30 days notice. That was foreseeable. Unforeseeable leave has to happen as soon as practicable. And that can mean a number of things. Generally speaking, as soon as you're, as the employee, are aware of your need for leave, you need to tell your employer that. If possible, that has to happen within the time prescribed. That's not always possible. In the context of migraines, for instance, if we have a call-out procedure that says you have to call out at least 2 hours before the start of your shift, but the onset of the migraine doesn't happen until an hour before the start of the shift, we would have to deviate from that policy in that context because that was as soon as practicable. 15 days to provide the certification. They must provide complete and sufficient. Incomplete means that they haven't filled out all of the questions. Insufficient means that the information doesn't allow you to actually evaluate what they need. Like if the doctor has said they need time off, well, that's insufficient information to allow me to determine how much time off they need. If it's incomplete or insufficient, we have to notify the employee and then give them 7 days to amend or correct. If there are doubts as to the validity of the certification, there are mechanisms by which you can send an employee to a second or third opinion. You have to have a doubt as to the legitimacy of the certification that is real. You can't just be like, yeah, I don't like this guy. I don't think he seems full of it. If the doctor's signature looks forged, or if something in the certification itself seems, well, wait a minute, no doctor would ever write this, and you have a legitimate basis for questioning that, we can send to second and third opinions. We can directly, yes, ma'am.
The 15 days, is it business days or are we including weekends?
That's calendar days.
So if you're on a school calendar, how, is it days the schools is open?
No, it's calendar days.
So if school is closed?
Well, there are some specific rules with respect to schools and how leave is managed that we'll talk about. If the school is closed, I don't know how we're getting into the process, right? But like if somebody notifies you of need to take leave on December 15th, the certification's due, and you send them the certification that day, the certification's due December 30th. Now, again, that's not something that you're going to want to be inflexible or intractable about. If your deadline happens to be December 30th and the school's closed from the 16th through the 5th, you know, you're not even going to be there on the 30th to look at it, right? If the person says to you, hey, can I get some more time? I'm almost always going to tell you, you should tell them yes. There's no downside to giving them more time. There's only potential liability if we try and hold their feet to the fire on that. Does that make sense? And honestly, you can proactively say, you know, if the return deadline's December 30th and school opens again on the 6th, you can make it the 6th in that context, as long as you do that consistently.
What's considered a healthcare provider?
So, doctors, psychologists, therapists.
Do you have one in mind that you had a employee ask on?
Well, I've had a chiropractor.
A chiropractor is a healthcare provider. Let me see if I can get this right. Only if they've diagnosed a subluxation of the spine through an X-ray. And I think there's one other aspect to it. But like, if you get a note from a chiropractor saying Tommy has diabetes, that's not appropriate. It's only for diagnosis of subluxation of the spine through an X-ray, I believe.
So any kind of therapist or psychologist, it doesn't have to be technically a medical doctor?
Does not have to technically be a medical doctor. I'd have to look at what level education or licensure the therapist would need. A physical therapist? I don't know that off the top of my head whether a physical therapist would be sufficient, because I'm not, you know, I don't know, like, can you be a physical therapist if you just have like a sports injury BS, or is there some other licensure to be a doctor? If you're a doctor of physical therapy, that's almost certainly allowed. If you're just somebody that you know, is yeah, I know at our school growing up, we had like a athletic trainer, exactly. That certainly wouldn't constitute somebody. But physician's assistants, I believe, can, as can nurse practitioners, yes. So we can reach out to the healthcare provider to authenticate a certification, meaning, did you really fill this out? Is this really your signature? Or to clarify, which means, what the heck did you write here? We can't ask for any additional medical information, though, without a HIPAA release from the employee. Candidly, the doctor's not going to give you any more medical information without a HIPAA release. There are some instances in which we can request recertification. That tends to be with chronic conditions or conditions that somebody's taking intermittent leave for. We can request one no more than every 30 days, but that has to be in connection with an absence. Generally speaking, that usually doesn't come into play, because oftentimes we see for intermittent absences, we see a certification that says the employee has migraines, they need approximately 3 to 5 days off a month for the next 6 months. If that's what the certification says, you can only request recertification after that 6-month period. There are certain instances in which you can request one if the employee's circumstances change. You know, if it is they're going to have to miss 2 days and then all of a sudden they need 10 days, you know, you can get a recertification in that context. If we have information that casts doubt on the need for leave, you tie this into our social media presentation. You're on social media, the person has told you they need to be out because they have a broken arm, and they're posting pictures of them playing intramural basketball. Wait a minute, that's a context where you could request a recertification. And then the employee requests an extension of leave, that would allow you to request a recertification.
Okay, so sometimes it's hard to see how to operate within these. So, case study, we had a preschool teacher shows up to school with a black eye. She starts taking breaks at odd hours and begins calling other employees at home repeatedly at night, babbling. Parents complain that they don't want their children in her class. Employees express concern for the teacher and the safety of the children. And these facts are a little changed, but this is a situation we had. So, any thoughts on what you might do in this situation with this teacher? So, okay, so this is where you can require a fitness for duty evaluation. If there's a reason why you think that they are a safety threat to themselves or others, or they can't do their main jobs, you can require fitness for duty evaluation. And so this would be a good situation to do that in, because this person is clearly a risk to herself and possibly to the kids. So you can require her to consent to the evaluation. If she refuses, you can terminate her employment. Again, I would say that, but I would really try to work with her, because this might be someone who doesn't even see her own issues. You may need to work through that with her.
It sounds like a domestic abuse survivor. That's what it sounds
Yeah.
And that's an excellent point. And I should say in Philadelphia, there's actually a domestic abuse leave law. So if you're in Philadelphia, you should also think, well, wait a minute, this implicates that law as well, and I need to go through that process to discuss that with the employee also. Is anyone in Philly proper? Okay. So just keep in mind that if you saw a fact pattern like that, that may also implicate Philadelphia's domestic abuse leave law.
In all of these situations, we really want you to try to work with the employee. Like, even though it says if she refuses, you can terminate. Yeah, you can, but really try to work through this, because as you're pointing out, you might talk to this person, find that there's something very different going on. You want to understand what that is. It might not be an FMLA or ADA issue. It might be something totally different. So you don't want to jump the gun on these kinds of things. You can place her on a paid absence while the process is underway. And if the doctor confirms the disability, then document it. So you always want to go back to your documentation.
How do you pick the fit for evaluation provider?
Well, you can, if that person has one, you can talk to them about their doctor, or, there are doctors out there who work with schools on these kinds of things. So, I mean, it depends what kind of, if it's a mental health issue, it might be a mental health doctor that you're sending her to. So you want to think that through. Now, I would tread very lightly on this situation, because you are talking about someone who, you're going to have checked for mental issues. But if you really feel like they're a threat to themselves or the students, and it's a real issue, then I would go this way. Especially because you guys are in a very unique situation where they're dealing with kids. So you can't have someone who, and the next slide even brings this up even more, you can't have someone who's not dependable supervising kids.
Can you pay for that as an employer?
Yes. That's also true in the FMLA second and third opinion context. And
What's the person saying they're being treated by their spiritual leader?
so it doesn't matter, in a fitness for duty evaluation, it doesn't matter what they're telling you. This is your opportunity to say, no, we want you to go see somebody that we trust at our expense to make sure that you actually can perform the job.
Do they have any recourse for a second opinion? Kind of like with FMLA, as an employee, you get to ask for a second one, but can the employee request a second one if they don't like what they do?
Boy, that's a good question. I think I would want to know more context in that situation. So the fitness for duty analysis is obviously going to implicate the ADA, and we'd have to go through a whole discussion about whether sending them for a second opinion would be a reasonable accommodation in this context. We'd also want to know what the fitness for duty evaluation said, and what our actions were going to be right before we played it out. So let's say the fitness for duty says, yes, this person needs 2 months off, and they come back and they say, oh, I want a second opinion, this is ridiculous. Do we need to, if we're just going to give them the 2 months off and allow them to return? No, not necessarily. Under a reasonable accommodation analysis, that would be an appropriate accommodation. The employee's not entitled to an accommodation of their choosing. But I could envision other scenarios where, this is a borderline issue, or, they're actually making a good point that there is something questionable about this. Or, we send them to a psychologist, and, the issue seems to be not psychological, it seems to be biological in some way, you know what I mean? So like, I'd really want to know more about the particulars of that situation before we said yes or no.
And just to give you another viewpoint, so representing schools, I might say, no, we're not going to do another one, only because if you get one where it says she's not fit for duty, I might want to err on the side of not risking another one, even though Michael might be right, you might, under the analysis, it might be a gray area. But what if you get the next one and it says she's okay? I mean, geez, then are you going to bring her back and have her supervise your second graders, So those are kind of things you want to talk through with your counsel.
And that's a great point, because
sometimes you're managing risk.
When you're dealing with students, there's always a point where the law meets the practical reality, right? And at the end of the day, we're going to be in front of a jury in any discrimination claim. And if our argument is, we did this way because we weren't comfortable having that person teach your children, I'm going to be okay with that, right? We've had times where we tell our clients, yeah, the law is not going to allow you to do this, but like, what jury is going to convict it? And I'll give you an example. We had a client who was going to hire a CFO, and it turns out in the background check after they had done the conditional offer, the CFO was a registered sex offender. And they called and they said, our building is right next door to a school. What do we do here? And I was like, I'm not sure that the law would take that into consideration. You're only allowed to consider that if it's job related. But like, what's the jury going to do here? Are they going to hold you accountable for not letting a sex offender work next to the school? No, not in a million years. So that's the same kind of thing. Like, if we're at a point where we're choosing safety of students versus, maybe some technicality of the FMLA or ADA, I'm always going to be comfortable saying the judge or jury is going to understand why we did this.
So another case study, the preschool teacher was evaluated and has a seizure disorder. She's been medicated and now wants to return to work. You had a great substitute and don't want the teacher back. The teacher insists on returning to her classroom. Any thoughts on this? Say that again? Yes, and I would be careful changing the duty unless you really had a good basis for that, because it's very easy to make a job look unfavorable. Yeah, yes. Yeah. Now, what do you think, though, about the fact that she has a seizure disorder? Do you think, are there any issues, like what if she's supervising her kindergartners? Would you want to know more about, okay, well, how often is the medication totally taking care of the seizures, or could you still have them? Any thoughts on that? Yes.
I would just keep the substitute as an assistant.
That is a very good option. So a couple things to think about. And that's the last one, is have a second person in the room to assist her. So that would be great. If you can afford to have that second person, that's a great solution. But this might be where you have the fitness for duty evaluation to see if she can really return to work. And you want to make sure that this is where you really need to provide the doctor with information, because you want the doctor to understand, this is a kindergarten teacher as opposed to a 10th grade teacher. Now, I'm not sure you want to trust your 10th graders more, but the law would probably say you could probably trust 10th graders if she does have a seizure. But you want to make sure the doctor knows this person's supervising children, interacting with parents, has to use judgment, has to deal with safety, and make sure that when the doctor responds, they're keeping that stuff in mind. And maybe, as you were saying, try to negotiate a different position for the same pay. So, yes.
Does that teacher have an obligation to notify anyone who is in HR she has seizure disorder? So like that second adult is in the group, she has to tell them, so they know what to do if she has seizure.
So I'll see what Michael says. I would say that this would be part of the interactive process. So if the doctor comes back and says, this medication cured her, she's fine, she'll never have another seizure again, then probably not. But if the doctor comes back and says she could have a seizure and it will be late in the day, then part of the accommodation might be to tell the second person, because they need to kind of be on the lookout for that.
No, I think potentially she could be
Yeah.
forced to tell. I will say, I have never seen a situation like that where the employee hasn't been willing to do that, right? And let's be honest, 99.9% of teachers are going to have the best interests of their students in mind. So I can't envision a situation where a teacher would know that that would potentially be problematic and not agree to let you tell, or not herself or himself tell the aide or whomever's there to assist. Always best to get them to agree to allow you to do something before we go through the analysis of whether we can make you.
But keep in mind, you'd want to explain to her, we're doing this as an accommodation to enable you to continue teaching. If we can't tell this other teacher, then we can't have you in with the kids because, so usually it works out, but.
There's also in that context would be a distinction between saying the teacher has epilepsy and just so you know, the teacher has a disorder that may cause seizures. If that happens, do X, Y, and Z. You know, you don't need to give the specific diagnosis in that context. You may just need to provide enough information to the aide so that they're aware of what may happen. That's a dicey situation, but those employees work for the school, and they're there to do what the school instructs them to do, right? So, yeah, well, if you're not comfortable existing in that environment, doors over there.
I think it's going to depend on what the situation is too. I mean, if it's someone.
Yeah, I mean, we should be clear that the law is not going to obligate you to hire somebody to be an aide in that context. That's certainly an appropriate thing to do, right? If the school has the financial means and the capability of having someone assist that teacher in that way, great. There's nothing that would prevent you from doing it, but there's also no obligation under the law to hire an entirely separate employee to be there in that context. Now, certainly if there is another employee who's already there, it's fair to have an expectation that that employee be prepared to handle the class, because candidly, that expectation already exists on that person. You know, if there was some emergent need for that teacher to leave, unrelated to epilepsy or whatever condition, that's why that person's there to begin with, right? So if their concern about being there for the class is truly related to the medical condition of the other teacher, that's not a valid concern. You know, we expect you to be prepared to manage the class at any moment. That's literally why you're here.
No, but I think her question was more along the lines of needing to take care of the adult.
Yeah, right.
Why is the adult responsible? Right.
Well, no. You're not foisting on them a responsibility to take care of the person. You're foisting on them a responsibility to take care of the class, which already exists. Now, if some emergency happens, you would expect an adult to call 911 if there's some emergency, regardless of whether it's a pre-diagnosed disability. I mean, this is a situation where I would be very, very aggressive in responding to any employee who said, well, I don't want to be here to take care of that person. That's not my problem. And say, well, it's your job to take care of the classroom in this situation, and I don't think it's too much to ask that you would pick up your cell phone and call us or 911 in an emergency. And candidly, if you're not prepared to do that in this situation, I'd be concerned that you wouldn't be prepared to do it in an unanticipated emergent situation.
Well, and let's be clear too, we kind of skipped over the undue hardship, so we jumped to this because it's a great way to handle it if we have the resources. But it may be that, you don't have the resources to hire a second person, and you need to do the assessment of, can you have someone with epilepsy teaching the kids, Maybe you could have them come back as teaching a higher grade. Maybe if they're going to have a seizure day, you can't accommodate that. that would be an undue hardship for the school. So that's going to kind of be the assessment that you make, and it may work out and it may not. So we kind of jump to that, but that's definitely not the default where you have to keep hiring assistants for everyone.
I mean, that's certainly going to be the right answer if there's already an assistant in the room.
And I think too, like, I'm not sure what your situation was. This was someone who might have a seizure. Now, if the doctor says she could have 20 seizures a day, and your employee's pushing back on, geez, I'm going to have this person on the floor 20 times in a day, and I know you have kids with special needs, that might be okay. Now, that is a hardship to have. Even a second person can't handle that type of. But if it's, geez, in the next 3 months, she might have one seizure, and you need to kind of keep her safe while she, then that's a different assessment. That's where I think Michael's saying you got to tell your employee to buck up and deal with it.
Yeah, I mean, again, the frustrating thing about the accommodations process is that we're going to have to go through an analysis in that process for every single time it's brought up that has to be independent. It's required to be independent. So if you have a situation where there's already an aide in the classroom, that's going to affect the analysis. And my reaction to that is what I just said. If you don't already have someone else in the classroom, to Susan's point, it's very rare that we're going to suggest that you hire or staff a position that doesn't already exist. That's almost never a reasonable accommodation.
But just keep in mind, it's very fact specific because, as she's saying, like, your school has physically challenged children who that teacher might already be dealing with 3 issues. And so to add on another teacher with issues might be a hardship. So we'd have to kind of do the analysis.
Yeah.
It's a very different situation.
No, and to your point, if it's a 20, this could happen up to 20 times a day, that's totally different than, this condition may have a seizure 3 times a year. If it's 3 times a year, it's not unreasonable to say, hey, we just need to be prepared for this if it happens. If it's 3 times an hour, that's a totally different scenario. Does that make sense? There are certain and special FMLA rules for schools. Intermittent leave taken for a period that ends with the school year and begins the next semester is leave taken consecutively. So like if you have a 6-week leave request, and 3 weeks are at the end of this year and the next 3 weeks are at the beginning of next year, not in June when everyone's at home. We don't count leave taken during breaks against employees. If you're an instructional employee who was on leave at the end of the school year, have to receive the same benefits after the school year as though you had been working. Yes?
When you say benefits, does that mean your pay also?
No. Yeah, FMLA leave and ADA leave are always unpaid, absent a policy by the employer that says otherwise. If you choose to pay employees during leave, that's your choice, but it's certainly not required by the law. Intermittent leave for more than 20% of the working days during the period of leave, the school can either require that the employee take leave for a duration not greater than the duration of the planned treatment or transfer the employee temporarily. Obviously this is again a very fact-specific situation where you need intermittent or reduced schedule leave for a particular amount of time. If you're not given proper notice, you can require an instructional employee to do 1 or 2. Instructional employees who begin leave, keep in mind this is for instructional employees, right? So if you just have someone who's a secretary in an office, these are not applicable. Obviously the logic is, we don't want to have teachers coming in and out of classrooms for the students. Begin the leave more than 5 weeks before the end of the term, or at least 3 weeks, and would return within the last 3 weeks, you can make them extend their leave through the end of the school year or the end of the term. Keep in mind, as you read through the other 2, that the school may require leave through the end of the term, but for the FMLA, you can only have 2 terms. So if you happen to have 3 terms and like the second one ends at spring break, you need to pick which of the 2 terms you're going to apply to this provision of the FMLA, which allows you to extend leave beyond what was requested for instructional employees. Yes?
So in that situation, when the school is requiring the person to stay home, then they'll be entitled to pay?
No, you're still not entitled to pay.
Even if the person wanted to come back and you said no.
Yes. You don't count the time against them, though. So FMLA and ADA have different job restoration requirements. The FMLA job restoration requirement is that you be put in an equivalent position. Now, that can be affected by established school board policies and practices, or private school policies and practices, or collective bargaining agreements. To the extent that this is going to be changed through your school's policy, that has to be in writing. The policy has to explain what the restoration rights are in that context, and any change in position has to have equivalent pay and benefits.
Okay, so another case study. John, your computer science teacher, has been late to school a few days each week during the past month. When you ask him about his late arrivals, he says that he and his wife have to share one car temporarily, and he cannot always get to school by the start of the day. He asks if he can be given FMLA leave for the period of time that he will have to be late while they share a car. What are the school's rights and obligations? Right, good. An easy one, right, so no obligations. Now, what if he said, though, hey, yes? That's what I was going to say. So what if she has MS or cancer and the aide can't get there until 9 o'clock, and that's why he's going to be late? That might be a different analysis, because then the spouse may have a serious medical condition that he is helping her with, and so that might qualify as FMLA leave.
But if she had to take the car because she can't take, like, that would not be.
Yeah, because she had to take the car to go to the doctor?
No.
Oh. Okay. So again, ADA protects employees with disabilities, so they have to have a disability. It's not just leave. And reducing their schedule or attendance is an accommodation. Unfortunately, I think that's one of the most frustrating ones for us to deal with, because we need school to start at a certain time. The kids are coming at a certain time, but it may be that that's something you have to give as an accommodation.
Yes. You're entitled to doctor's notes under the ADA in the same way that you're entitled under the FMLA. An employee's refusal to give you a doctor's note under the ADA is similar to under the FMLA. It allows you to proceed with disciplining for whatever the case may be, if that's necessary in that situation. But you should give the employee time to return the note, a reasonable amount of time, and if they ask for an extension that seems reasonable, I give them that as well.
So this is kind of where Michael was talking at the beginning about how all these intersect. So you might have an employee who's out on FMLA leave for something, and now that FMLA leave is ending and they need to come back, but you don't want to just say, okay, you didn't come back, you're fired. That's where you might need to look at, well, why are they out? Is it now a serious medical condition that you should now be considering an accommodation for it? So that's where you're going to need to, have a conversation with them. How's it going? What's happening? Are you coming back? And again, if they need to now have an accommodation, you need to have a different conversation, get information so you can assess that. Yeah.
So we have a teacher out right now who should be returning to their, she was 1 week left of school. And they are hoping she was not return because they want to hire someone else. They're not necessarily on the hook when you heard that she doesn't come back until next week. Offer her ADA, how's that work?
Well, it depends on what the reason is for the FMLA. So keep in mind that the FMLA can give you leave for the serious health condition of a family member or for birth or placement. Neither of those are ADA conditions.
So hers is for herself.
Okay, so then yes, you would have to go through an ADA analysis of whether additional accommodations were necessary. In this context, you may have some problems because an additional week of leave that would get your employee to summer break and allow them to return in September or whenever your school year starts is like a 30-second conversation that we would have on the phone, right? Like, they said they need 1 more week. Yeah, I can't envision a scenario in which an additional week off is not reasonable. In fact, in this context, the FMLA says you could make them take that off, right?
So this is a teacher that would have numerous students leave.
Now, so that's a whole separate consideration, right? You're still allowed to discipline people who take leave. It's just we have to be much, much smarter and much, much better at it.
Like, that's where you want to think about, do you have documentation? Had you been doing that before she went out on leave?
Yeah, I mean, if we have emails from parents saying, hey, we're not sending Susie back there because of this teacher, and there are 7 parents, and this has been an ongoing problem, the leave is irrelevant to that. We have some slides a little later that will kind of walk us through how to handle those situations.
Right.
Yeah, that's always
Yeah.
a possibility.
See, she's been paying attention. Okay, so, legally you do not have to offer open-ended indefinite leave, but I would be very careful with that because we do commonly have people where the doctor says they need 2 more weeks, they need 2 more weeks. I wouldn't say, oh, it's indefinite, we're going to fire. But technically, the law does say you don't have to give an indefinite leave. And it should be granted unless it's an undue hardship, and that's a very tough standard. So there are cases that really make employers bend over backwards. A year of leave has been approved. Now, they're going to look at your circumstances and see whether it's going to be a hardship for your school. But if you've accommodated that kind of leave for other situations, you're going to be expected to do it here. And there's no real magic bullet. You really need to look at what the situation is like in your situation, what's happening, why is the person out, have communications with the doctor, is it a serious medical condition and an accommodation could help. I guess you could consider if you're being played, but I really think, the law unfortunately benefits the employee, so I wouldn't, dwell on that. I would just try to have the discussions.
Yes.
Yeah, definitely.
All right, so the interactive process is what we go through when we're talking about accommodations under the ADA. It has to be an informal process between the employee and employer. We should conduct as much dialogue in person if possible. What we want to do is elicit information from the employee about what his or her needs are and what his or her abilities and or restrictions are. We want to get doctor's notes. We want to get the employee to identify the accommodation and then consider the feasibility of that. Obviously document the process and document the outcome. The reason we want to get the employee to tell us what the accommodation is they may ask for something that's quite reasonable and frankly is less than what we would have ultimately had to offer, right? If the employee asks for X and that's easy enough to give to him or her, give them X, document it, and there'll be no basis for a complaint down the line. If we can't give the employee what he or she asks for, propose alternatives. The employee in the ADA context does not have a right to get whatever he or she wants. It has to be a reasonable interactive process. Continue having dialogue with the employee, and ultimately if the employee's asking for A and we're willing to give B and we conclude that B meets the employee's needs, make the decision and communicate that. And then monitor the effectiveness of that accommodation. If it's working, great. If not, let's get back together and go through this process again. The best interactive process, and by best I mean least likely to result in legal liability ultimately, is get the employee to sign off on what the essential job functions are. Why is that important? An employee is only entitled to an accommodation that will allow him or her to perform the essential functions of the position. So if you have a teacher that's asking you to take them out of the classroom so that they don't have to teach anymore, they can't perform the essential functions of the job with that accommodation. Now, if the teacher says, take me out of the classroom for 2 months and then put me back in, that may be a reasonable accommodation under the law. But if you have a bus driver that can't drive a bus anymore, there's no accommodation that would allow him to fulfill the duties of bus driver. Limitations on the expected duration, we want to know that as well so that we can set deadlines in our documentation consistent with what the doctor recommends. If the doctor isn't clear, go back and get additional information. again, we can send the employee for an independent medical examination under certain situations. And the last bullet point, I think, is the most critical. If we go through this process and we come up with an accommodation and the employee is happy with that, get the employee to sign off on it. Again, our obligation through this interactive process is to come up with a reasonable accommodation. If the employee signs off on it down the road and files a lawsuit saying we didn't accommodate, our defense is, you said that this was good. That's a great position to be in a case, if the employee has agreed to the accommodation that you've offered. If we're not going to give the employee what they've asked for, let's provide some explanation for that. We talked about the second bullet point. If there's no accommodation that would allow the employee to do the job, we should also look at whether there are any vacant positions that the employee is qualified for. So in my bus driver analysis, if the bus driver comes and says, I can't drive a bus anymore, and we have an open receptionist position, well, maybe the bus driver is qualified for that and can take that role. If you would then move into the terms and conditions of that role. We don't have to keep him at the bus driver salary. We can pay them whatever the receptionist makes in that context if we're switching jobs. But again, we may conclude that a bus driver is not a competent receptionist, and if there are no other jobs and they can't be the bus driver anymore, then it's appropriate to terminate the employment.
Oh, you think so? Okay, well, this one was talking about a direct threat when you have an employee who's kind of a risk to your school. And it is tough, you know, the standards for an employer to not let someone come back because of a direct threat are difficult. You really should look at it independently, send them to a physician. But I have to tell you, this is where I feel like, you know, you guys are in a different situation. So although that's, you know, there's some risk in not accommodating someone in that circumstance, you guys have to balance, you know, the fact that you're dealing with students and your community. So you might want to not have the person come back if you have those types of situations. Okay. So, and we'll give you these slides. We want to try, I guess we want to try to get through one more thing. But these are the types of accommodations you don't need to give. And one thing I think I hear a lot about is you don't need to give them a new supervisor. So that's good. You know, sometimes employees will say, it's just my supervisor. You don't need to change that. Is there really such a thing as an undue hardship? It is hard to meet that, but, you know, feel free to talk it through. I mean, sometimes we can say it's a small school. We don't have the resources. We can't accommodate it. You want to go through your slide?
Why is it important first that whether or not an employee is uncooperative? If an employee is the one who isn't engaging in the interactive process and we terminate the process and the employee, we are not held accountable for that. It sort of makes sense logically. If you're not participating with us to develop an accommodation, then we're not liable if one wasn't found. What are some of the things that we look at to see whether the employee is uncooperative? You know, if he or she's not responding to communication, if they're rejecting reasonable accommodations, if they're not engaging by providing requested medical documentation, et cetera. If the employee is engaging in that behavior, we don't keep having to ram our heads against a brick wall. We can terminate the process and the employee. But certainly before you do that, I would encourage you to discuss it with your attorneys. Obviously, we shouldn't say anything that suggests that we are holding the disability against the disabled person. You can imagine how those things will play out in court. I do want to spend a few minutes talking about terminating leave takers. You know, we've discussed a few times about, well, what if the employee is resulting in people withdrawing from the school, but you know, they're disabled? Well, you're still entitled under the law to hold employees accountable for performance and attendance standards, even if they're disabled. So if you have an employee who is causing you to lose students, regardless of their disability, you're entitled to address that in a disciplinary way. You know, the easier cases in that regard are You know, if someone's leave request is fabricated a doctor's note, right, that you can certainly discipline them for that. You know, if the employee sets up a new business while they're on leave, first of all, your policy needs to forbid that if you're going to hold them accountable. The FMLA says you can forbid employees from engaging in alternate employment while on leave. Has to be in your policy, though. I would double check that. But if they're doing that, you know, you have a right to discharge them for that. Tougher cases. If you have somebody who's committed an infraction, let's say, before the request or commencement, but we discover it after the request for leave or commencement of the leave, it's still appropriate to investigate and discipline that. Now, of course, you can imagine what it looks like if so-and-so comes to you on Tuesday and says, hey, I need leave, and on Wednesday you find out that the employee's been stealing from the company, and on Thursday you fire them. You're going to see a complaint that says you fired me because I asked for leave. That's a timeline, however, that's supportable in front of a judge or a jury. You know, hey, we can demonstrate we didn't find this out till after you requested leave. We took immediate action, and it had nothing to do with your request for leave. Obviously, documentation of the timeline in that context is going to be critical.
But I do want to just emphasize that because we do have, you know, schools, we want to let them finish out the year, but it's devastating when, you know, in March, then they report that they have a disability or they raise some kind of leave issue. And it really is, that's a case that's going to go to trial because it's going to be a summary judgment issue. So
yeah.
Just consider that when you, because we do like to hold off, but if something comes up in the meantime, it's going to make it hard for you to terminate without risk of a claim.
And this is exactly the what's contemplated here, which is, you know, we have an employee that we're hoping doesn't come back from leave. He or she's been doing a bad job. We were kind of expecting the problem to take care of itself, so we haven't done anything. Now they're on leave and they're saying they want to come back, and we're thinking, well, crap, we don't want you back. That's an exceptionally problematic situation to be in because you knew about the performance issue before they left. You didn't do anything, and then once they left to take leave, then all of a sudden you decided it was a problem. We're going to have a lot of trouble defending that lawsuit. You know, we may ultimately in front of a jury be able to prevail, but it's probably going to get that far, to Susan's point, because the timing of it just looks bad. And their argument's going to be it wasn't a problem until you knew I took leave, and I can show that because you knew about it. You didn't say anything until after I took leave. You know, if we don't have prior documentation, I don't mean to suggest that we should just ignore it. Start it. Gather anything that you had available before the leave was taken. You know, but don't go back when they come back from leave and say, hey, there was all this stuff going on, so you're on final warning. You know, start the process now, start documenting it, let them come back, and let them continue to have poor performance, and then start disciplining it from there on. You're still potentially going to have a claim in that context for retaliation, but at the very least, you're going to have documented the process and have given the employee an opportunity to improve the poor performance. If you have a reduction in force, you're allowed to terminate an employee who's on leave. Of course, in this context, the documentation becomes critical. I can't tell you how many times I've gotten a call saying, hey, we have an employee on FMLA leave, but we're going through a reduction in force. Can we fire them? And I say, sure. Tell me about the reduction in force. Well, we're just eliminating that person's job. Okay, let's start over. You know, if you have a reduction in force that is is a company-wide reduction or that has some sort of objective metric, that's going to be the most defensible, right? If you decide the last person hired is going to be the first person out, and this employee on leave happens to be that person for this department, that's a very winnable case, right? Especially if you did that in other departments. But again, that all has to relate to your documentation and the strategy around going through the reduction in force.
And just so you know, if you do a RIF, you do want to consult with some counsel because if you do severance agreements, you need to do certain language in them and everything. So, you know, that's a little bit of a trickier situation. So the leave taker who can't return, again, don't automatically terminate them. You need to understand why they're not going to return. Don't have policies that just say if you don't return, you're fired. I think we've covered most of this. Okay, failing to reinstate to the same pre-leave job. As you were saying, the FMLA doesn't say it has to be the same job, it has to be an equivalent position. But do be careful if you don't return them to the same job, because they can often find ways to distinguish them. As it says, one person's equivalent position is someone else's demeaning demotion. Okay, I think we've pretty much covered this. Yeah, so do you feel like, am I missing anything?
No.
Okay. We're trying to speed it along because we've spent a lot of time on this, but do you have anything you want to say on this, or you think you've covered it?
No, I mean, the basic point here is that if you hire that replacement employee for that temporary period, don't just fire the other employee because you like this one better. That's going to be, we're going to have a very tough conversation if you do that. Also keep in mind, workers' comp is relevant here in a couple of ways. If someone is out on workers' comp, you should designate that time away as FMLA so that that runs concurrently with their absences. Workers' compensation is not actually a statute that relates to leave in any way, shape, or form. The workers' compensation laws don't obligate you to give employees time off. You know, it runs concurrently with the FMLA and ADA, which may. Workers' comp is a payment statute. The reason people give employees leave instead of firing them when they're on workers' comp is, A, you can't retaliate for taking workers' comp, and that would look bad. B, if you fire someone who's on workers' comp, it's going to cost you more money. We talked about this and how we need to be very intentional about disciplining people when they return from leave. I just said that. You, Sarah, really just want you to be aware that if you have someone who's in the uniformed services, they are entitled to certain reemployment rights following a deployment or active duty. What's very important to keep in mind under USERRA is it has what's called an escalator provision, whereas the FMLA obligates you to return an employee to an equivalent position they had when they left. USERRA requires you to return an employee to a position they would have had they not left. Meaning that if you have a standard track for promotion, you have to escalate that person up that track, right? So if you have a system where teachers in years 1 through 4 get paid X and 5 through 8 get paid 9, and he or she leaves at year 3 and comes back at year 5, they need to go into that year 5 category.
So I think we've covered that. We were going to take a few minutes, and then I don't know if you guys want to stay for a hostile work environment. We could touch on that quickly. Or if you feel like you'd rather maybe do a webinar on some of these topics, up to you guys. Any thoughts? Or? We could probably cover hostile work environment in 20 minutes. You want to do it? Okay. Do you want a few minutes first before we keep going?
Are you freezing?
Okay. All right. Okay. So you guys want to just keep going? We'll just plow through it? Okay, awesome. We're probably not going to get to sexual abuse or child abuse and reporting. We can give you the slides, and feel free, you know, we take calls on simple HR matters, so if you do have questions with that, feel free to call, and we can also do a webinar too.
So a couple things to keep in mind. We're going to talk about sexual harassment. It's important to note that the rules that we're going to talk about with respect to sexual harassment are the same with respect to harassment on any other protected category, whether it's race, religion, gender, etc.
And let me just add that this is not really a full sexual harassment presentation. Aggie just really wanted us to touch on what is hostile work environment, because there's a lot of misunderstanding around that. So we could talk about this for a good hour or two, but we're just going to really focus on one little aspect.
So
I know you're disappointed about.
There are two types of hostile work environments / sexual harassment. One is quid pro quo harassment. That sort of is what it sounds like. It's where a promise has been made to an employee in exchange for some sort of favor, or a threat against an employee has been made in exchange for some sort of favor. You know, either I'll give you a promotion if you do X, or I'll fire you if you don't do X. That's quid pro quo harassment. A hostile work environment is creating an environment that unreasonably interferes with a person's work performance or creates a hostile, intimidating, or offensive work environment. Same-sex harassment is considered illegal So in the quid pro quo harassment situation, we touched on the first 2 points, but the last one's important. You know, if the threat continues, even if the promotion or demotion doesn't actually occur, if it continues, that's still a hostile work environment, right? So the simple threat in and of itself is enough to have the liability. It doesn't actually have to come along with the promotion or demotion.
So you kind of understand there's like that one that's a quid pro quo where you're asking for sexual favors in exchange for something, and then we have hostile work environment, and that's unwelcome conduct based on sex or race or color, religion, one of those protected categories. So we always hear about the hostile work environment, and I think it throws us off because we think, okay, the boss is a jerk, that's hostile, but it has to be based on one of those things. So we often get calls saying, hey, you know, you could have, I had a school where a supervisor was terrible, wasn't, you know, giving people time off when they needed it, was kind of berating them. Now, you might want to still fire that person, but technically, if they're effective and you want to keep them, that's not a hostile work environment unless they're doing it because their employees, you know, are pregnant or on leave or something protected.
And this is one of the most misused phrases in employment law. Is, you know, we often hear people who come and complain, well, I'm being subjected to a hostile work environment. And we're like, oh no. And then you look into it and it's really just, you know, my manager's a jerk. Well, you know, that's not great, but that's actually not against the law. So good news there. I also want to focus on that hostile work environment has to be severe and pervasive conduct. Now, that is again a sliding scale. The severity of the conduct can directly relate to how pervasive it needs to be. You know, so if we're talking about minor offenses, minor slights, that's stuff that has to be happening constantly. The more serious the conduct, the less pervasive the court's going to say it needs to be. But one thing to keep in mind is that the law actually says sporadic usage of racial epithets or inappropriate language in and of itself does not create a hostile work environment unless it's so severe and pervasive that when viewed in the totality of the circumstances, it alters the employment conditions. That's an incredibly surprising reality, is that, you know, you could have an employee actually use a racial epithet, and that in and of itself is not going to subject the school to liability, because the law says one instance of using that word is, or, you know, one of those words, is not a hostile work environment by itself. It has to be pervasive.
But I will just mention the counter to that, which is that take it all very seriously, because every time we get one of these cases and you think it's going to be, oh, just one or two things, it's always, there's been much more that wasn't reported to you, that employees didn't think was a big deal. So and then then it does look like a big deal. So, you know, yeah.
And the one you had earlier, when it was written, it can be used against you. I feel like in a greater sense, because if it's written on social media, if it's written somewhere, then it lives on.
It does live on, yeah.
No, that's a great point. And Susan's point's an excellent one. Whether or not the law classifies the use of a racial epithet, for instance, as a hostile work environment is irrelevant to how we choose to respond to that as a school, right? Obviously inappropriate behavior, obviously incredibly serious, potentially should lead to the person losing their job. That's a separate analysis from whether or not that actually created a hostile work environment under the law. Susan started to make the point that, you know, it seems unlikely that if a person is willing to say a word that's inappropriate in the workplace on one occasion, that he or she hasn't been willing to say it on other occasions. You know, so you want to make sure that we're having our eyes and ears open and just dealing with the practical reality of that. Just jump in if you want to.
Well, and I just want to mention, too, that another thing we see when we get into litigation is that, oh, they thought it was funny, the comments were funny until there's litigation, and then they're offended by it. And so just, you know, if you are hearing things, you should really investigate and shut it down, because it's all funny until somebody's, you know, first of all, until somebody gets terminated or something happens to them, and then it was harassment. Yep. Or, you know. So.
Yeah, people's tolerance for things tend to change based on whether or not they're actively employed, right? Yeah. It is also important to keep in mind that the workplace is not simply where you go to work as far as hostile work environment is concerned. off-premises school events, school conduct. So we talked about social media and how social media can relate to hostile work environment claims. That's because the law is going to treat that as a business-related issue. Social settings. We also have to keep in mind that it's not just employee-to-employee conduct. We have an obligation to our employees to prevent them from being harassed from anyone. So if the parents are doing the harassing and that comes to our attention, we have an obligation to stop that. And you're going to say, well, how are we supposed to tell a parent what to do? Well, that's not easy, but your obligation in that context is to the employee. And if you allow a parent to continue harassing an employee, you're going to potentially be liable for a hostile work environment. There are a number of different ways or a number of different things we could do to prevent that. If you have a vendor that's doing it, if you have a student that's doing it, if you have, in any context where in a school-related setting, somebody is harassing your employee, you have an obligation to prevent and correct that. So that's a good question. I mean, that always depends, right? And I think your first response to the teacher in that context should be, if you feel uncomfortable, contact law enforcement immediately, right? Because in the Chipotle, there's only so much that you as the school can do. Now, if that behavior is happening there, we need to make sure that it doesn't continue to happen in places that we can control, right? We're not going to be found liable if every time the teacher goes to Kmart, some guy is harassing them. But we will be found liable if we knew that the guy would harass her at Kmart, and then we are inviting him to come on campus where we know he's going to do it, right? So if the teacher's telling us that's happening at Kmart, we need to say to the parent, A, this is inappropriate, B, you're not allowed on campus, or you're not allowed to these events, or whatever it is, so that we can say, look, we can't control Kmart. If she wants to go there and he wants to go there, we can't control that. But what we did do was say, you're not allowed on campus, you're not allowed to do this, that, or the other. Or candidly, at some level, our handbooks, our parent handbooks and student handbooks should allow for us to withdraw the student based on the parent's conduct. You said you had a harassment question earlier today. I said we were going to talk about now. I totally forget what it was.
Well, it was the saying on Facebook, supervising social media, like, say, hey, why is it really bad guy? She's on her Facebook page. She's nosing about it. I guess I was getting bullied or harassed or something like on the other side, right? I mean.
So remember the last couple of slides we looked at. If she's just posting about you and saying you're a jerk, and it doesn't relate to your race, gender, age, disability status, no, actually that's not harassment. Now, under the law, under your school's policies, it very well may be, and most likely is, and it's still conduct that you could be held accountable for, right? But under the definition of what harassment or hostile work environment is, that's not actually, that doesn't actually constitute illegal harassment. Again, distinction between what the law is going to cover and what the school has a desire to prevent, right?
Well, and the school could also terminate her for it because she's not protected for that, Yeah.
Yeah, that's not NLRA protected conduct,
Right.
exactly.
And I just want to mention that what Michael's talking about with hostile work environment comes up too more in like the admissions context, and unfortunately sometimes with our bigger donors, and especially when there are events where there's alcohol. So that's where you just want to keep your ear to the ground because sometimes we do have parents who act inappropriately in those settings. So.
What about a parent who asking a teacher out on a date? Like, where's the line?
So that is not something that would inherently be hostile work environment, right? If I came up to a teacher and said, hi teacher, would you like to go out on a date with me? And she said no. My wife would be very unhappy about that, first of all. But, she said no, and that was the end of it. That's not inherently problematic under the law. Nothing necessarily inappropriate has happened. The problem will come is if it continues to come up, right? We talked about it has to be severe and pervasive. Now, certainly as a school, we can decide, hey, in the parent handbook, we're going to make it clear that you're not allowed to date our teachers, or that we have an expectation that you don't do that. Now,
The person was was actually married and teaching you he was married, but he was.
It wasn't me.
And he kept like propositioning a teacher?
He stopped, but I mean, but she had to see him every day when he dropped his kid off.
Right.
The kid was young, and it's just kind of like, you know, so for her, it was a very uncomfortable situation.
Yeah, and I think in that context, that may be the type of situation where you want to consider having a policy in the parent handbook or in the contract that makes it clear that that's not tolerable. You know, it may be a little, you may have a different feeling if you're a 9 through 12 school where the parent and teacher aren't going to interact that much. You know, that's purely up to the school. The school, if they don't have the policy, just needs to be prepared that if that behavior continues and starts to sound like what we talked about a few minutes ago, that you're going to have to step in and approach the parent and let them know that's not appropriate. And if it doesn't stop, that, you know, you'll have to not come to campus.
I would recommend that you do that. I mean, there's nothing inherently wrong with it, someone asking a teacher out, but if she says no and he's still persisting, I would definitely feel like you should step in.
Oh yeah, 100%. In fact, at that point, you have the obligation to.
The kid thing.
Yeah, problem
Take care of
solved.
that.
So it's also very important to keep in mind, a lot of the examples we've just discussed about harassment are verbal communications that people have had. That's not the only type of harassment there is. There is visual. You know, I've had a case once where, you know, somebody hung a Michael Vick doll from a noose, and somebody complained about that being harassment. Obviously not a cool thing to do, but that's a situation where that was visual harassment, where that was an item that was hung up. Doesn't have to be spoken. There's also, of course, physical harassment, inappropriate touching, etc. Again.
Well, and something that's that egregious like that might be something that in itself is enough. So, you know, severe and pervasive, if it's one really bad thing, could do it.
And physical touching especially can lead to other claims that are not necessarily harassment under Title VII, but assault, battery, things like that, where the school could potentially be liable for an assault claim if you knew or should have known that the employee would do something like that. Yep, I'm sorry.
So on the severe and pervasive, so if you know your teacher who, for instance, or comments, whether it's under any of these protected classes, and you approach them about it, but then they say, oh, I didn't mean it that way, or, you know, how do you handle those cases where they think that what they're saying is perfectly harmless, you know, intent versus impact?
Yeah, that's not a defense at all. So you should talk to them and say they've got to knock it off, and otherwise
Yeah.
they'll be disciplinary.
Key point, it is the impact and not the intent of one's behavior that determines whether or not it's harassment. So, you know, in this slide,
And look at all
it
these
was
things,
just a
because this is
joke.
what we hear when you talk to the supervisor, and these are not acceptable, so.
It was just a joke is not relevant to the analysis. And again,
And sometimes you need to explain to them, like, look, that might be funny at your football party or on the weekend, but you're in the work environment and you have to act a certain way, and this isn't acceptable here.
and I want to touch on this because I think this is incredibly important. You know, in everything we talk about in employment law, it's like there's the 50% of it that we're talking about because it's good and you know, you want to help employees be better, and the other 50% is purely talking about avoiding legal liability. This is that. It's so critical to handle harassment claims appropriately because that is a defense to a harassment claim, a legal defense, meaning if someone reports to you that they've been the subject of a hostile work environment, you know, so-and-so is making the jokes, and you investigate that, and you discipline appropriately, and you otherwise have had policies and procedures in place, and you've done training, the court's going to say the employer is not liable for that conduct. Even if it's a supervisor, the employer is not liable for that conduct if you exercise reasonable care to prevent and promptly correct harassing behavior, and the employee unreasonably failed to do that, right? So if they didn't report the first 100 comments to you, and then on the 101st, you do all the things you're supposed to do, you will not be legally liable for that. That is a huge, 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 huge hugely important aspect of this, and why it's so important that when you get information about a harassment or hostile work environment issue, that you take those steps that we've been discussing throughout the day. Because if you fail to do those two things, and a supervisor was engaging in the harassment, your company will be liable for it. This is critical. And one of the most important defenses we have in these situations is we didn't know about it. As soon as they told us about it, we did exactly what we were supposed to do.
And this is one of the policies you absolutely want to have, is an anti-harassment policy.
Any questions on that?
I have a question. We have a supervisor who is her secretary. She does not particularly care for her secretary's husband. He has a criminal background. Years ago, robbed a bank, committed things crime, and then recently robbed a liquor store and just got an ankle bracelet removed. And she just don't feel comfortable with him in the area. She said, I don't mind him if he's coming to pick up his wife, you know, meet her at the front entrance, but I don't want him in my program with my elementary students. I don't feel comfortable with him in the area.
So that's not actually a harassment problem, right? Because he's not, his simply existing is not severe and pervasive conduct on the basis of one's protected category, right? Now, that doesn't mean you can't lowercase a accommodate that. But if you let everyone else's employees come in,
Spouses, yeah.
spouses, I'm sorry.
Yeah.
All of your employees. If you let everyone else's spouses come in and all of a sudden they're saying to this person, wait a minute, you can't come in here, I would have some very serious concerns as to potential claims that could result from that.
But this might be a good time to think about, like, maybe we should have a policy that says, hey, spouses should kind of stay in a waiting area, or, you know, not wandering through your school, and, you know, I mean, you might want to err on that side and have a policy that restricts it.
Now, of course, if he has said or done something, totally different. If his, you know, if he's walking in and, you know, coming over to the desk and talking and, you know, invading personal space or other things that are distinguishable from anyone else's spouse who's coming in, of course, yes, let's focus on that behavior and make sure it's clear that that's not allowable. But if it's simply the fact that a person is existing in that space with a criminal record, as opposed to everyone else who doesn't have one, I'm not really sure that there's a whole lot that we can or should do about that, other than, to Susan's point, implementing a blanket rule that would prevent anyone from doing that, which may be the right answer. Depends on how much you want to keep that person who's complaining. So one other thing that's important to keep in mind is that not every hostile work environment allegation or complaint needs to result in termination. Certainly there are some that we would all look at and say, obviously termination is the right result. If there's been some sort of physical touching that's clearly beyond the bounds, okay, of course, termination's appropriate there. If there have been, you know, use of racial epithets or threats or things like that, of course, termination's appropriate. But there are a number of offenses where termination isn't necessary, and actually termination's not necessary to avail yourself of the defense that we discussed. You have to take appropriate remediate action. Well, let's say somebody tells an inappropriate joke. Giving them a written warning may be appropriate remedial action in that context. Let's say you have an employee who comes up and puts his hands on, you know, there's a female employee sitting down and comes up and does, you know, the massage situation. You know, that's not necessarily conduct that needs to be terminable on the first offense, right? You can discipline that in a written warning or some other type of documented discipline. Still have the defense available to you. If that person's coming up and obviously touching private areas or anything like that, no, that's straight to termination, right? But there is a level of conduct that you don't have to terminate for. Now, of course, you may decide that that's appropriate. That everyone in the workplace nowadays should know you can't walk up and massage your coworkers. If you don't know that, you know, you shouldn't work here anyway, because I'm not confident in your mental faculties. But you know, you can of course choose to terminate for that behavior, but you don't always have to. And certainly, if you call us or anyone else, we can talk through those issues with you.
So, I mean, I think this is straightforward. Who can commit harassment or discrimination? Male to female, female to male, male to male, female to female, manager to subordinate, subordinate to manager, customer, clients to employees, and vendors to employees. I think Michael covered that. I think we kind of covered this too. I mean, so as Michael said, like, you're responsible for vendors who come on. If you have someone delivering food service stuff and they're acting inappropriately, you need to stop that.
And in that context, you call their employer and say, hey, here's what was alleged. Don't send this person here anymore.
Any questions on that? We just wanted to kind of go through it just so you get a sense of what hostile work environment is, since it comes up a lot. Any questions or issues, or?
And your employees to understand that that actually is what a hostile work environment is, or what harassment is, so they have to be based on those categories.
Yeah. This is something we do a lot of training on, and training's really helpful because you do have a lot of weird situations. Like, I went to school and the coaches came up afterwards and they're like, we hug everybody, you know, especially with kids. Is that wrong? And I mean, there are a lot of difficult situations. There was a woman at a school and she's like, that's just my thing. I hug everybody. And you just need to think about, okay, how is that going to be perceived? And again, especially with the guys, sometimes it's all well and good until they don't like John anymore. And now they don't like that he's giving him a shoulder massage. So we do a lot of training on this, and you might want to do it. And there are great online resources you can do just so people are aware that it's just different in the workplace.
And it's even more difficult in situations where you're dealing with boarding schools where, you know, not only do you have a totally different relationship with those people, you're living on the same floor together, and those people are truly parental figures. And, you know, every situation is unique in that regard, which is why, you know, it's important anytime you get a whiff of something inappropriate or, you know, any indication that somebody has a problem with something, that you need to investigate that particular situation and respond to it accordingly, right? If you have a coach that's hugged a student after a victory and that's the only allegation, I'm not going to say you need to terminate that person necessarily.
Well, and even if you don't hear that the employees have a problem with it, if it sounds weird, like if everybody in the science department is hugging each other all the time, you should still investigate that because, again, that one person might be in there who doesn't like it, you know?
Great chemistry class. Bring it in here.
So I wouldn't just wait for complaints. I'd just try to keep your ear to the ground.
Well, that's a very important point, is that somebody doesn't have to come to you and say, I think I've been subject to a hostile work environment. Could you please investigate that, right? If you find out through whatever means that there's behavior that is sort of like, wait a minute, there's a physical touching here, this, you know, what's going on, you should investigate that.
Great. Yeah, cuddle parties are out.
At least get a waiver.
Great. Well, thank you very much. I don't know if you have any other questions, but I think that's
Thank
it.
you so much, Susan and Michael. I haven't even had a chance to lunch. Thank you so much, and thank you all very much. We'll get the slide deck out to you, and feel free to stop by. Thank you again to our sponsors, Praesidium and Lancaster-Lebanon IU 13. Have a great afternoon. Thank you. Yes, did you register?